minutes.
And then you're whisked away. Come in, everybody.
Is that okay?
Ma'am, now I shall have to be. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, the first case we're going to hear this morning, United States v. Brown, and Mr. Carpenter, we'll hear from you first.
May it please the court. We're asking this panel to remand this case for resentencing in light of Erlinger and to reject the government's harmless error arguments based on any one of three separate and independent rationales. What I'd like to do is to begin by very briefly identifying each of those rationales before then diving more into the details of each. So the broadest potential rationale is that the reasoning of Erlinger itself suggests that harmless error review is not appropriate in this context. The second rationale would be the middle ground position, that for the relatively small subset of Erlinger errors that also qualify as constructive amendments, this court's precedent presumes prejudice. And then the third argument would be the narrowest, which is that if a case-specific harmless error inquiry is appropriate, the government cannot meet its burden in this case to show, beyond a reasonable doubt, that the outcome would have been the same but for the error. I would like to start with the middle ground position on constructive amendments. And I would like to start by clarifying or attempting to the relationship between constructive amendments on the one hand and Apprendi errors on the other. And I think the best way to describe that relationship is through the classic Venn diagram of overlapping circles, because there are constructive amendments on the one hand that have nothing at all to do with Apprendi. There are Apprendi errors on the other that do not qualify as constructive amendments. But what we're dealing with, I believe, in
So
this
just for an example, Whitfield is a constructive, at least as the court understood Whitfield. Whitfield is a case about constructive indictment, but not an Apprendi error.
No, Your Honor. Actually, Whitfield is in that middle of the Venn diagram.
Okay, sorry.
So if you look at pages 306 to 308 of Whitfield and footnote 14, the primary argument on the merits that the government advanced there was that the death results finding was a sentence enhancement and not an element. This court's first step in its analysis was to apply the Apprendi line of cases, including Jones, to conclude that
There is no such thing as that distinction from a constitutional perspective, right? Like literally
Correct.
every case since Apprendi has said that is gibberish, that does not exist.
And that was, exactly, that was step one in the court's analysis in Whitfield. And again, if you look at 306 to 308, it's applying those cases. Jones, footnote 14, cites Apprendi specifically and says this is an element, it must be submitted to the jury. The court then turns to what this means. And what it finds is when an element is not listed in the indictment, but then is submitted and found later in order to apply an enhanced offense, an enhanced sentence, that is a prototypical or archetypal constructive amendment. And that is exactly what we have here.
Which case supports that? The Supreme Court, I thought, is defined constructive error much more broadly. It has to be an error that permeates the entire case from front to back. And they have actually held that when an element is missing out of the indictment, you conduct a harmless error, plain error, whatever the error analysis is, and not presume prejudice.
Sure. So I think, Judge Niemeyer, I understand you to be asking about structural error, and that is the broadest of the rationales, and I understand there are some hurdles to that argument that would require the court to read cases like Netter and Requinco pretty narrowly. And so I'm happy to advance those arguments. That's what the Carlton case in New Jersey did do. But for the purposes of this case, or at least to begin, I'm focused on the narrower argument about constructive amendment. And this court's precedent, including most importantly Whitfield, has said that if an error qualifies as a constructive amendment, prejudice is presumed.
Let me ask you this. Does Brown contest the accuracy of the convictions below, or did he?
So the answer to that is yes, but it doesn't really matter. Our view is that at Joint Appendix page 53, our objection went to everything, including the facts. I recognize that in the initial panel opinion, it suggests that we didn't contest the accuracy of the dates, and we're okay to accept that. Because what we undoubtedly did and continue to do is to contest the occasions finding. That even if you accept that the dates of the prior convictions were separate, that does not equate to a single or a separate occasion under the Wooden test.
Well, if we agree with you, where I think you're headed, aren't we setting up a circuit split?
So I think I would need to clarify exactly where you think I'm heading, I guess. I would acknowledge if the broadest rationale one, the broadest structural error argument would be a circuit split.
Harmless error analysis regardless.
Yeah, so I think if you get to
Really arguments 1 and 3, right?
Right, I think argument 2 hasn't been addressed by any circuit.
Sure, but arguments 1 and 3 would both create circuit splits.
So I think 3 would not, because so both the Sixth Circuit and the Fifth Circuit since Erlinger have applied harmless error review. And so on step 3, we would be doing that. Then it's a case-specific finding. And so I don't think we would be creating a circuit split with those decisions, because we'd have different facts here than they had there. So I don't think it would be a direct split in that sense. I also think there's a threshold question in the harmless error analysis that neither of those, again, assuming we're on argument 3, that neither of those courts addressed. And that's the question that I think was flagged by this court's notice about the Hayward case, which is the question here, would a jury necessarily have convicted? Or because we're in a guilty plea context, is the question, would he have taken a chance at trial on the occasion's determination? And we think that that is probably the correct
I don't know
standard.
if the case is even whether he'd take a chance at trial. I think the question is, would he have pled guilty? In other words, what we're talking about here, if I understand it correctly, is he's warned of the enhancement. What he's not warned of is that the enhancement has, at least for our purposes, 2 elements. One, a violent felony, which the court's going to find, and 2, on different occasions, which the jury's going to find. And the question is, if he was alerted to that, would that have changed his plea? Would he have not pled guilty? And I think, I thought the Supreme Court has recognized that difference in several cases, especially in Greer and.
I agree with that. And so I think then, Judge Niemeyer, the question is, if he had been aware that there was a jury trial right on the enhanced occasions offense, would he have pled guilty to that offense?
I think that's the question, yeah, I think that's fairly, that's it.
And I think just to clarify, because it's a slightly strange posture with a baseline offense and an enhanced offense, there's no doubt he accepted responsibility of the baseline offense, and there's no doubt.
Having the firearm.
You're right, possessing a firearm after a felony conviction, he's confessing guilt to that offense. The question
And
is.
he's also accepting, when he pleads guilty, that the district court is going to make the finding on whether his predicate offenses are violent felonies.
Right, and so the question is, if he had known at that time that I have a jury trial right on this occasions element, would he have taken that issue to trial?
So can I separate, there's two errors here, right? There's arguably, there's 2 possibilities for error here. There's an indictment error and there's a Rule 11 plea colloquy error, right?
I would add a third with the constructive amendment, which could, but you know.
I just view that as an indictment.
Sure.
Posit that
It's a
just view that as
category
an
of it.
indictment error.
Yeah.
There's an indictment error and there's a colloquy error. Now, let's start with what I think is good for your client, which is your client's indictment, as far as I recall, says nothing about the ACCA.
correct.
Nothing whatsoever about the ACCA. That seems like a real problem, especially under Whitfield.
Yes.
Except then there's the part of the plea colloquy where the judge says to him, sir, if you plead guilty, there's going to be a question about whether you have these 3 occasions.
Yes.
And I'm going to decide that, not a jury. And his lawyer doesn't object, at which point it strikes me that any error to the Rule 11 plea colloquy is totally forfeited.
So I don't think that is correct.
Why not? The judge said something, the judge, in the course of advising the defendant of what the consequences of pleading guilty are, says, no shade on the judge, this is pre-Erlinger, but in light of Erlinger, that was a legally incorrect statement during the plea colloquy. And,
Sure.
and to give some more grace to the judge, it's not as if a reasonably savvy defense counsel at the time could not have thought of this argument. That, actually, judge, that's wrong. I object to you telling him that. I preserve that issue.
Right.
And they didn't.
So I think what you said is no reasonably savvy defense counsel would have made that objection, because this plea colloquy happened before even.
But but hold on. Cotton, Johnson, we don't care that no reasonably savvy defense,
Right,
you're
that's
charged with
not
thinking
our
of things
point.
that haven't happened yet.
I agree. So I think there are 2 reasons that the lack of an objection in the middle of that Rule 11 colloquy should not affect preservation.
Well, preservation of the guilty plea colloquy, not necessarily preservation of the indictment issue, right?
Sure. I think both are preserved, and let me say why I think the Rule colloquy is preserved. I think it's preserved for 2 reasons. One is that the advice he's given is boilerplate. It's given in every 922G indictment. If you happen to have these things, you'll be subject to it. He was not informed in his indictment that the government was even alleging that in his case. So I think that's point 1. He objected as soon as somebody told him, you have 3 objections and are subject to this. When that came out in the PSR, he objected immediately. The second reason is this is a bifurcated Rule 11 proceeding. If you look at Joint Appendix page 17, the guilty plea in this case is not accepted at the end of that hearing. It is solely recommended by the magistrate judge that the district court ultimately accept the plea. Before that plea is accepted on Joint Appendix page 24, where you see the district court judge accepts the factual basis, the objection is lodged by that point, that we believe we have a jury trial right on this thing you are seeking to apply.
But you still pleaded guilty.
Again, and there's no.
This would have been a lot easier if this was just a conditional guilty plea.
Sure, but I don't think I think it's unfair to a defendant to expect that when you're preserving something in the face of not only adverse circuit precedent, but a wall of adverse precedent across every circuit. Sure. So I think that, that is what makes this case a little different in its procedural posture, is I think he did everything he reasonably could have.
Well, let's back up. In the actual plea in front of the magistrate judge, he was warned about the enhancement.
He was given, it was stated that if you have 3 convictions, it's a conditional warning. If you have 3 convictions, and then you would potentially be subject to this.
Nobody knows at that point in time for sure.
Well, yeah, I think the point is,
Well, I guess he would have known if the indictment had mentioned that.
he would have known, yes, exactly, and I think that is a big, and that's why this case looks a lot like Whitfield. If this were a case where the indictment said you're subject to 924E, you have 3 prior qualifying convictions, we would not have a constructive amendment error. This would not look like Whitfield. And so I think that is.
I don't understand the constructive indictment, and that's, it involves a jury context where you go to a jury. Here, we're pleading guilty. To me, the indictment provides notice and prohibits double jeopardy. Those are the real roles of the indictment. And here, the indictment missed an element. But he's advised of the element that is facing him during the hearing. To me, the question then comes, would he have not pled guilty if he'd been given the fact that part of that enhancement has going to a jury and part's going to the judge?
Sure, and so if we accept that as the inquiry, I think there are 3 reasons why he would not have pled guilty to the occasions element and would have taken that aspect of this case to trial.
Before you go there.
Sure.
My simple mind, you're using the word occasions and date.
Yes.
The date is the offense of which the offense occurred. What's the occasion?
So the occasions inquiry under Wooden is a multi-factor test that does not rely solely on the dates. And we see that in the jury verdicts.
Then do we start parsing out whether it happened 3 months apart, a year apart? We have to get into all that?
I don't think you do, Your Honor. I think that's exactly what the jury is for in this context. And that's what in Wooden itself, Justice Gorsuch wrote a concurrence saying, look, this test that we're setting out does not give juries instructions on what they do when these factors point in different directions. And that's precisely why he would have taken this to trial and taken a chance with a jury. And so the point here is, because he was not advised that he had the ability to take this to a jury, I think the inquiry, if it's would he have gone to trial, the answer is yes. He would have taken a chance.
I want to give you a chance to respond to. So Leggins is really bad for everything you're saying right now. I assume the answer to that is that Leggins does not even acknowledge the existence of Whitfield, and thus under our one panel can't overrule another. You think we just disregard what Leggins says?
I think it's maybe slightly overstating it, but in that direction, I think the reason I think that Leggins doesn't control on the constructive amendment claim, yes, is that the defendant there did not present a constructive amendment error. If you look at footnote 18, the court says the presentation of the Apprendi issue by defense counsel was, quote, far from clear. Based on the messiness of the briefing, it excused the government's failure to argue harmless error. And so I think the court acknowledged, look, we are basically creating this Apprendi argument for the defense.
But none of that would matter. What matters is the court literally does not mention Whitfield.
The court, yes. And so, again, if Whitfield is on point, which we think it is the prior decision, and so the court would be bound by it. If we end up in the inquiry of would he have taken occasions to trial, I do want to quickly tick through the 3 things that I think suggest he would have. One is the contemporaneous objection. As soon as he was informed this is applying to you, he objected and said, I think I have a jury trial right here. That contemporaneous objection suggests that if that jury trial right had been available under precedent, he would have taken it up. The second factor is that he has a reasonable jury argument on the occasions issue. And I acknowledge, Judge Floyd, assuming the dates are different, there are at least 3 of the factors under the Wooden test that point in his favor. Those are the purpose, the character of the relationships, and the purpose and the character, and also the relationship. On the relationship, I would highlight the state consolidated these, treated them as imposed a single sentence. We think that's a strong argument for a jury. The third, the court will allow me to quickly throw out the third, is his sentencing exposure is huge in this case. It's a big difference from a 15-year minimum to a 10-year maximum with a guidelines range of 90 months that cuts in half his exposure. Why not take the risk when you have that much to gain? That's why we believe he would have went to trial.
All right, thank you, Mr. Carpenter. You have some rebuttal. We'll get coming back. All right, Mr. Enright.
Thank you, Your Honor. May it please the Court, Anthony Enright for the United States. The earlier error in Brown's case is harmless under the Leggins standard or under the Hayward standard. Erlinger told us that it was applying the principles of Apprendi in its holding, and Leggins holds that Apprendi is subject to harmless error, as have a long line of cases going back 25 years. And it tells us that the way to conduct that analysis is ordinarily to examine whether, if the missing element, in this case the different occasions element, had been submitted to a reasonable jury, can this court say beyond a reasonable doubt?
Sure.
that it
Well, that
would
makes
have found
total sense in the context of the question of whether there's at least for me, conceptually, it's very important to distinguish between indictment errors and jury errors.
I can
That makes
understand
100% sense to me in the context of jury errors. It doesn't seem to make any sense to me at all in the context of a guilty plea error. That question, framing the question what a jury would have done in a case where the defendant pleaded guilty and so there was no jury, does not make any sense.
Well, Your Honor, I think the error is ultimately the same, because what the court held in Erlinger
Well, I don't think it is the same. And I'm not even convinced constructive amendment is at issue because we don't have a jury context. What we have is an indictment and a guilty plea.
I agree with you, Your Honor.
And the error was not including in the indictment and not advising about the enhancement portion, one of the enhancement portions going to a jury and one going to a judge.
I agree with
And
that, Your
the
Honor.
question is, would he, had it been listed in the indictment and he had been told that the other occasions would have been decided by a jury as opposed to the judge, would he have pled guilty?
Yes,
or
Your
not?
Honor. Yeah, under that,
And I think their argument is that he should have been given the chance to, he might have, because of the differential in the five-year differential in incarceration, at least a minimum 5-year differential, would have caused him to go to trial.
yes, Your Honor, we agree that he should have been given a chance to take this to a jury trial, but the error in this case
No,
that occurred,
that-
I'm not arguing with Your Honor at all. What I'm saying is, I think we know how this would have come out had the choice been put to him, because he was informed.
Well, that's for an analysis between him and his attorney, not for the jury. Now,
Correct.
the attorney could say, if a judge ruled on this, it would go this way, but if a jury ruled on this, it would go that way, and I think we ought to take the jury shot. In other words, that type of discussion would have taken place, but we're not forecasting, we're not, as a judge court, forecasting what a jury would have done. We're forecasting whether he would have still pled guilty or not.
Yes, Your Honor, and under that framework, the answer, we win, because he told the court told him, if you plead guilty today, there will be no jury trial. The court will decide at sentencing the rest of this. And he was told what might happen is the Armed Career Criminal Act might apply, your mandatory minimum will be 15 years, your statutory maximum will be life, and there will be no trial. Do you still want to plead guilty? And he said under oath, yes. That is as good of evidence as you could ever get that.
Well, I know, but he's not told that the jury not only decides your guilt under 922G1.
That is true.
A jury also determines an element of your enhancement.
That is true, Your Honor. To the extent he wants to say that an error occurred, that an error was complete at the guilty plea, however, and that he would have reached that result, he needed to raise that at that time. He didn't, therefore he needs to identify contemporaneous evidence that he would have gone to the other
Then
direction.
there's a forfeiture problem. But then we have a
Yes.
forfeiture problem, because the
Yes.
last time we were here, the government never suggested any of this was forfeited.
Absolutely 100% true. And I'll tell you, I didn't even think this through until after we'd asked for rehearing. I didn't think it was an appropriate time to raise a different framework.
Okay.
But I think either one, I can understand why this court might examine both frameworks. And I think under either one, the framework is, we win.
Can I ask you, so I'll just say, I'm far more troubled by the indictment problem than by the jury problem, than the plea colloquy problem in this case.
Certainly.
Does the government have to see, so I want you to posit a defendant who is in fact eligible for an ACCA enhancement. He in fact has 3 prior convictions that were in fact committed on 3 different occasions.
Sounds familiar so far.
He's being prosecuted under 920 for being a felon in possession, right?
Yes, Your Honor.
Does the government have to seek an ACCA enhancement?
At this point, no, Your Honor.
I mean, I just matter as a matter of prosecutorial. I guess I think we can take judicial notice of the fact that the government routinely does not charge people with crimes that they are in fact guilty of, and routinely maybe does not seek enhancements that it could in fact get.
Yeah, we have discretion to say we're not going to seek that, we're not going to present that to the grand
That's a
jury.
little more complex in this case, because
It is.
number one, the statute says he shall be sentenced if he has those conditions. And number two, the aspect, a big important aspect, is decided by the court in sentencing, and he has to do it. One element is now reserved to the jury under Erlinger. That makes it complex, because that one element, the government could say, we're not going to charge 3 different occasions.
Correct, and that will tie the
And
court's
that
hands.
would probably then eliminate the ACCA enhancement, right?
Yes, Your Honor, and that gives us the discretion to do that.
Well, that sort of follows up a little bit on what Judge Heitens was.
And you don't have to include ACCA. Now, again, let me rephrase. Post-Erlinger, may I assume that the government is charging ACCA enhancements in the indictment, including that they were convicted on occasions different from one another?
Yes, Your Honor.
Okay. And so this case would be really easy then, right? Because if the indictment said you're subject to sentencing under the ACCA, and you in fact committed 3 previous offenses on occasions different from one another, and you pleaded guilty to that indictment.
You've admitted all the elements of the charge.
You've admitted
Yes,
everything,
Your
and we
Honor.
can sentence you under the ACCA. So this is really, absent someone just screwing up, this is just a transitional problem, right? This is a problem of what we do about the pre-Erlinger cases that are working their way through the system.
It is, until it's a pretty limited, the case we have today, I think, affects a pretty limited case.
Because
set of
going
people.
forward, I take Judge Niemeyer's point, but going forward, if the government just leaves ACCA out of the indictment, as a practical matter, this defendant is not getting an ACCA enhancement.
Correct, Your Honor.
Okay. So once we posit that, why isn't this case literally just Whitfield? Because, I mean, I sort of, let me posit, Legan seems very inconsistent with Whitfield to me. Whitfield's way of distinguishing Hibbs is not overwhelmingly persuasive to me.
But it does distinguish it.
It does. But the question is, this to me, let me just maybe give you 30 seconds of why I think this case looks just like Whitfield. In both this case and in Whitfield, the indictment on its face has no problem. The indictment on its face is totally fine, right? Because in Whitfield, as the court concluded, the statute has 3 different crimes. The indictment charges 2 of them. That's fine. I mean, the government doesn't have to charge all 3 theories. So the indictment in Whitfield is in no way on its face defective. Same here. The indictment in this case is on no way on its face defective. Unlike the case we're going to hear next, where the indictment mentions the ACCA but doesn't really charge all the things it should under the ACCA, this indictment doesn't mention the ACCA at all. And the world is full of people who violate 922G who don't have 3 prior convictions.
Correct.
So there's nothing facially problematic about this indictment, just the same as there was nothing facially problematic about the indictment in Whitfield. And that seems important because Whitfield says that's a problem because the defendant could have looked at this indictment and thought, everything's fine. And then we get to this world where whoa, what's just... So yeah, with that framing, why isn't this case literally just Whitfield?
I think there are a few differences with Whitfield, and I want to start with what Whitfield said, which is this is a different case than Higgs-type indictment error. And Higgs says we're in the arena of Apprendi. Higgs was literally, he's convicted of murder.
Like a ring error. Like that's a ring.
A ring error, it's the same
Yeah, no,
error
no,
I think we have here, honestly, which is he's convicted of an offense, and then the court, and then in this case it's a sentencing jury, but the question is, what's his penalty going to be? Is it going to be life or death? They say that's a Higgs error, and the difference is it doesn't broaden the basis for a conviction. That's the posture on which we are here, because this court has held multiple times back, several other cases, that ACCA is a sentencing enhancement. It's in the same posture
You know what I'm about to say, right?
There's no difference.
Yes.
But Higgs is the one, Higgs. Whitfield is the case that draws the distinction. So if there's no distinction between a constructive amendment and a Higgs-type indictment error or an Apprendi error, then this court is bound by the Higgs line, or the Apprendi line of cases, which includes not just Higgs, but Higgs, Barnett, a case called Mackins that unfortunately, I honestly thought we had cited that up until this morning and realized we didn't cite it, but This is not something that Whitfield made up. It's like every other circuit that I think has addressed this and continues to maintain a distinction between the harmless error standard for Apprendi and the harmless error standard for constructive amendments. It treats them differently. And I do think the distinction is awfully nuanced, and there's many cases we can find, including Banks, which talked about Whitfield and really said there's no distinction between something that broadens the basis for a conviction and something
Because that just, once again, seems to be fighting the fundamental insight of Apprendi, which is that if you increase someone's sentencing range based on a fact, that fact is, like, for constitutional purposes, that is an element, whether you...
I think that's absolutely right. The only arena I'm aware of where a distinction exists is in this part of Higgs that my friend relies on. Or, I'm sorry, in the part of Whitfield that my friend relies on. If that distinction is no longer valid, or is invalidated either by prior precedent or by subsequent precedent, like Elaine, then this court is bound by the Apprendi line of cases.
Can you point to any pre-Whitfield case that is not Higgs? I know Higgs does. Other than Higgs, any pre-Whitfield case other than Higgs where this court concluded that an Apprendi error in the indictment, a preserved error in the indictment, is subject to harmless error review, other than Higgs?
United States versus Mackins, 315 Fed 3rd 399, it's 2003
And this is
case.
pre-Whitfield.
It's pre-Whitfield, 2003. We didn't, I honestly thought we cited it until this morning, didn't cite it, it's that. Another one is United States versus Barnett, which we did cite. Both of those cases held that addressed an indictment error, an allegation of indictment error under a preserved one, and applied the harmless error standard. So even if for whatever reason Higgs doesn't apply, those cases do. And my friend has also introduced this idea that an alternative holding, the reason that Higgs wouldn't apply is because it's an alternative holding, saying that alternative holdings are dicta.
Well, to be fair, Whitfield...
That gets Whitfield too. So the question is Leggins
No, I was
good
going to
law?
say, so you're going to cite the cases in which we have said multiple times that alternative holdings are not dicta.
But I think that's wrong, Your Honor, because there's earlier cases. Ford says where a court makes alternative holdings, each holding is binding precedent.
That's what I'm saying. No,
Yes.
I was agreeing with you.
Absolutely.
But the problem that I run into is that I read Whitfield, and Whitfield says that language in Higgs is dicta. Now, again, I might be inclined to disagree with that, but...
It does say it's dicta, but then it distinguishes it. It says the circumstance we're talking about is not Higgs-type indictment error. In other words, Whitfield is telling us it's not discussing a Higgs-type indictment error, and so to the extent it's addressing that, it's addressing something different. There's the Apprendi line of cases. There's the constructive amendment line of cases, and they're narrowly different. But this one is squarely on the Apprendi line of cases because Erlinger tells us that. It tells us that. And I think the point, I don't think it can be overlooked, that Higgs is simply not the only thing we need to distinguish. There's nothing that prevents, I think, the court in Leggins, which is really the question, is Leggins good law? There's nothing that prevents the court in Leggins from adhering to the same distinction that Whitfield is addressing. Whitfield says, we're talking about something different. Leggins is saying, we're not talking about Apprendi.
Can I move you then to the question of, let's posit for the sake of argument we're doing harmless error, and now talk about how you operationalize harmless error in this context?
Absolutely.
So let me posit, I know all of the cases that say when examining whether an error is harmless, we look to the entire record. And what I understand those cases to be saying is, just because the prosecutor said something dumb at one point during their closing, we don't literally look at that one sentence. And just because one part of the judge's jury instructions were problematic, we look only at that one part. And just because a witness blurted out something on the stand they probably shouldn't have been allowed to say, we don't look at only that. We look at the whole record, which we normally mean the entire trial transcript, right? And the government moves from that to saying we can look at the PSR. And that seems like a big leap to me.
Well, Your Honor, I think it's a matter of taking the Supreme Court at its word. It said that multiple times, it cited it in Netter. This court said the same thing. And every case we have from other circuits has done that. When they've looked at the entire record, we have the second, third, fourth, as of yesterday, the fifth, the sixth.
Where in Netter?
What's that?
I always thought it was Nader, but go ahead.
I know, I have no idea how it's.
I also don't. Go ahead.
I apologize.
So
You probably know
what
better
in
than
that opinion says that we look at the PSR?
It doesn't say we look at the PSR, but it relies upon von Ardsal, which says you look at the entire record to conduct the
Okay, now I go back to
harmless
that
error
case, and what does that case tell me? The entire. Yes, I agree. We look at the entire record. The question is, what is the record?
I agree that those cases are talking about, involve the trial. But first, the record has a meaning that is much broader than the trial. And
How do I know that?
Because it's a well-established defined term.
What case tells me that in conducting a harmless error review, I look at all the stuff as opposed to something else?
Well, Your Honor, I don't think you can read entire record to mean everything except. That
Wait,
I
no,
think is the plain meaning of that
I think
term.
it's entirely, and Nader, Netter, whatever it is, I think it's entirely sensible to say we look at literally everything that happened from the beginning of opening statements through the jury charge. All of that is the record. I don't know it says we look at things other than things that happened during the trial.
But here, Your Honor, I suppose is the question of, there's not any reason to draw that distinction because there was an error at the trial. The jury was told in Nader, for example, disregard this evidence. So it really doesn't make much difference. If this court can say...
But it makes all the difference in the world, because the hypothetical question being asked in Nader is, if the jury had been told you have to find materiality, what is the answer the jury would have given? And we're like, well, given all the evidence the jury heard, the jury's pretty clearly going to find materiality in this case.
Fair enough, Your Honor, but this court can still make that prediction. The counterfactual is still the same. This court can look at the PSR, and the question isn't what would they say if they had the PSR. The question is, does the record contain enough information that this court can predict with confidence that if the issue were submitted to the jury,
Well, no, in this case, if the issue, if he were told, as Judge Niemeyer pointed out, the question is, if he were told, if you don't plead guilty, you'd have a right to have a jury trial, and one of the things you'd have a right to have a jury trial on is the ACCA issue, right? Would he have still said, yes, I'm guilty?
And under that standard, I think this court could look at Hayward, where you look at the entire record to determine whether the defendant would have still pleaded guilty.
This is an embarrassing statement I'm about to make. What is the record that we described in Hayward, in your view? What did we view as being the record in Hayward?
In that case, it included his statements during his plea colloquy.
Absolutely sure.
It included a letter he wrote to the court at sentencing, which I think
I always
is
thought the
instructive.
record refers just to a record, which is what the clerk has maintained in the case. In other words, a clerk, of course, anything that's filed.
Filed in the
case-
court.
Filed in the case, not in the chambers of the judge. But
Yes.
it was filed with the clerk.
That's the well-established.
That's what I thought record is.
That's what I understand the ordinary meaning of record to mean. And if the court meant something other, if the court meant just what happened at trial, I would imagine it would use different language than saying the record as a whole.
But wait, hold on. Hayward's
I'm
coming
talking
back
about
to
the
me.
Supreme Court.
No, but Hayward's coming back to me, because in Hayward, the government in Hayward tried to submit a post hoc affidavit saying, like, this is what was really happening. We're like, we are not considering any of that. You don't get to submit on appeal affidavits.
I'm not saying anything that is not in the record
That'd be-
as the court, under Rule 10 at least.
Right, okay.
But under Hayward.
The
he-
PSR is part of the record.
The PSR, to be fair, it wasn't the PSR. He had written a letter at sentencing, and this court considered the letter at sentencing to be relevant to whether he had established contemporaneous evidence, and I think that is informative here. The other thing I would mention is every other circuit to look at this has looked at sentencing information, the PSR and Shepard documents for the most part. Every single one of them has taken the entire record, the record as a whole statements from the Supreme Court, and applied them to Erlinger errors that has addressed it. But that's a lot of courts. Second, third.
So the hypothesis here would be, once you understand the question as being, would he have pleaded guilty had he been reliably informed, I guess the hypothesis goes, he's probably aware of the stuff. And if he wants to claim he wasn't aware of stuff in the PSR, he's welcome to claim he wasn't aware of it, but he probably was aware of the stuff in the PSR. And given that these facts are true and that we presume he probably knew them, he probably would have pleaded guilty? That would be like conceptually how you would do that?
Yes, well, maybe not, Your Honor. I think the question ultimately would be, would he, the big picture question is, what can he point to that would tell this court that he wouldn't have pleaded guilty?
That he would have said, whoa, 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 I want to go to trial. Now that I
Yeah.
understand I have a jury trial right on the occasion clause, I want to go to trial.
That's probably a pretty broad universe. He needs to do something. My friend hasn't done that in
It's
this
a little
case.
dicey because the burden's on you, and what you basically argue, I gather, is that there is no evidence to indicate that. But the burden's not on him to come forward. He may want to.
That's correct.
He may want to point to evidence, but the burden still's with you, isn't it?
Yes, Your Honor, and the burden's with me. I think either way, if it's a preserved error, the burden's going to be with me, either to prove that he would have pleaded guilty or that the jury would have reached the same result. And I think we meet that burden by showing overwhelming evidence. These are his offenses were 72 days apart, and more than 5 years apart, separated by an intervening arrest in each case, and involved different victims. That's overwhelming evidence that at least puts him into a position where, look, if you've got a reason you wanted to go to trial on this, you got to point to something in the record, something some rational jury could have gone the other way, or some contemporaneous evidence that says, look, this was really important to me. I would have definitely taken this to trial for perhaps idiosyncratic reasons. I do see my time is almost up, so I want to make sure I address any questions this court may have.
But what value would we put on the fact that he either did or did not move to withdraw his plea once he found out?
I think that speaks volumes of the question. He was aware of that the court would that there would be one more hearing, the sentencing hearing. He was aware that there would be no trial, and he was aware that the court might apply ACCA, and that is true. And that occurred after he got his draft pre-sentence report that said, here are the offenses. And ACCA is likely to apply. The probation office believed ACCA was going to apply, and he didn't withdraw his plea.
Well, do we put more weight on that issue in that case, or?
I think so, Your Honor. The fact that he didn't withdraw his plea after he knew all the information that the ACCA was likely to apply speaks very highly to the fact that this was a harmless error. Under either because we didn't raise it, or because he didn't raise it, if he has the burden, or because we didn't raise it earlier because we have the burden. The fact that he didn't withdraw his plea after being informed that ACCA was going to apply almost certainly at sentencing shows that he would not likely have withdrawn his plea, or shows beyond a reasonable doubt that he would not
Of course, as I
he would have pleaded
understand,
guilty
at that
either way.
point, he's not informed about the Erlinger. Oh, yes, he is. No, he's not.
Erlinger didn't come down until after,
Yeah.
I'm sorry, Your Honor, I see I'm over time. Can I
Yeah,
answer your
go ahead.
question?
Yeah,
He hadn't been informed of Erlinger, but he had raised this issue. So he was aware of the issue, he was aware that it was
But as Judge
debatable.
Heitens pointed out, that as the law changes, you're still charged with the different, in terms of forfeiture, you're charged with the change in the law.
Yeah,
Even though you may not have subjectively understood it at that point.
yes, that is absolutely true. And I see I'm over time.
Yeah. All right, thank you, Mr. Enright. Mr. Carpenter?
Thank you, Your Honor.
Yeah.
Judge Floyd, let me start with your question, and I think that Judge Niemeyer essentially gave the right answer to it, which is that the reason he didn't move to withdraw the guilty plea at that point was because he had no jury trial right under established precedent. And the distinction, Judge Niemeyer, that you drew is exactly the correct one. A defense lawyer is going to advise a client in this situation. You're much more likely to prevail on this kind of occasion with a jury than with a judge. That's
Well,
particularly...
I don't know if that would be the advice, because
Well, I can tell you it would.
I
That is the
understand.
advice you'd give?
That is the advice we certainly give. And I think the other point to highlight for the court in terms of why there's no withdrawal of the plea at that stage is this plea was not only pre-Erlinger, it was also pre-Wooden, where the multi-factor test that Wooden developed that is much more defendant-friendly than the multi-factor test this court had previously applied in cases like Carr, because Carr and Wooden are the exact same facts, break-ins at a storage unit.
But at that point, you made the argument a while ago that he would have gone to trial over 5 years. Well, he knew at that point it was a 5-year difference.
He certainly did, but he had no jury trial right. And so I think the contemporaneous evidence that we point to in the record is the fact that we invoked the jury trial right in this objection, saying, we believe we have a jury trial right. I think the implication there is, if we're correct, we're taking this to a jury. So I think that's the contemporaneous evidence that we have, that he was aware and willing to go to a jury. And I think when you add the other factors on top of that, being the sentencing exposure, and the fact that this is a reasonable jury argument, and I acknowledge the government has the dates in its favor, but the other factors are in our favor, or there's just an absence of record evidence about them. So if you compare the facts here to the facts in Pennington, where the jury acquitted on the occasions, those were convictions separated by 4 months, not just the 2 here. That's a case where they involved prosecutions in different jurisdictions, different counties. And yet the jury found that there was enough of a relationship between them that they constituted a single occasion. Here we have a lesser time gap. We have the same jurisdiction, and we have the state prosecuting them together at the end of the day, imposing a consolidated sentence. I think it's a compelling argument to a jury.
Were there separate arrests?
There is a suggestion in the record that there was an arrest, but it appears that if he was arrested, he was immediately released. Certainly, that's a factor the government could point to in front of the jury saying, well, he was arrested, but I think a jury may not put much weight on that if he's arrested, processed, and immediately released. Again, this would be a question we believe worth taking to the jury. And so I think the three factors we would point to on that front, again, contemporaneous objection, huge difference in sentencing exposure, and a jury argument that is a reasonable one. And I would flag for the court, the 11th Circuit, as we pointed out in the 28J, has been remanding cases with similar facts, where there are different dates, and yet they're saying, okay, there's a chance that, we're sending this back, it's not harmless. In the McCobb case, it was 5 dates spread out over between June and August. The Barner case were 3 dates, January, February, and April. The court is finding these not harmless and allowing defendants the opportunity to exercise their jury trial rights if they
I
wish.
have a couple Whitfield questions.
Yes.
What do you say to your friend on the other side's argument that Whitfield itself was inconsistent with some pre-Whitfield cases that applied harmless error to Apprendi indictment errors?
So I will have to look at Mackins and Barnett because I don't, as the counsel,
Totally fair.
I don't believe they were cited, and I'm not familiar with them off the top of my head. I think the key point, though, is that the Higgs distinction, which, they're relying on Higgs for a reason. I assume it's their best case. We'll see if the others say something different. But Higgs is, Whitfield does not distinguish Higgs because it's an Apprendi error, because Whitfield itself is an Apprendi error. That's where I think the government keeps thinking it's not an Apprendi case. Again, if you go to Whitfield and look at pages 306 to 308, footnote 14, it's an Apprendi analysis. This is an Apprendi error.
Okay, so second question about Whitfield. The second problem with Whitfield for me, how isn't huge amounts of what Whitfield said not just diametrically inconsistent with United States versus Cotton? All of this stuff about indictment, Whitfield is basically repeating a lot of the stuff from Promise that Cotton is that is not how we do this.
Well, so I think the reason it's not is because Cotton is a prong 4 plain error examination, and Whitfield.
No. At the beginning of Cotton, before we get to prong 4, there's the part where we are just going to dispense with this idea that indictment errors are just catastrophically bad.
Sure,
There's that
but-
first holding of Cotton.
I agree with
And
that.
then
But
Whitfield says things that sound a lot like that.
that may be true, but I think maybe my memory is wrong, and I apologize if it is, but my recollection is that Cotton specifically reserves the prong 3 question.
It does. You're right.
Okay.
Well,
And
that is
so-
my recollection too.
Okay, so that is why we think that it would be different. The other thing to point out, in Higgs, the offense was charged. The death-eligible offense was charged in the indictment. It was simply an error with which aggravator, which is much more akin to an ordinary indictment error. And the final point I would make is Belcher is exactly in line with what Whitfield does, Belcher from the Sixth Circuit. So Whitfield is not any kind of outlier in that respect.
All right, thank you, Mr. Carpenter. We'll come down and greet counsel. We're going to, Judge Floyd is not going to come down. He's greeting you from the bench right there. And Judge Heitens and I will come down and greet counsel to proceed to the next case. All right, we'll proceed on to the next case, which has a similar issue. And Mr. Bringack, whenever you're ready, we'll hear from you.
Thank you, Judge Niemeyer. And yeah, we can just jump right in to the specifics of Mr. Boggs' case. I am Eric Brignac for Trevor Boggs. And I agree with Haywood and with you, Judge Niemeyer, with you, Judge Heitens. The question here is whether Mr. Boggs would have pleaded guilty. And I think diving into our record, I think there are 5 reasons to show that the government cannot prove that he would have pled to an ACCA offense. He would have gone to trial. So
Well,
first,
maybe just before you get to that, because it may bear on your argument, the indictment in this case alleged alleged that
Yes.
enhancement was going to take place. And it talked about 3 offenses as defined in Section 924E.
yes,
Does the indictment have to allege more? In other words, for
Yes,
instance, if it said instead of as defined in 24E, it said committed on 3 separate occasions, you could still argue that some other definitional thing. In other words, the idea that it's a violent felony. We don't, do we require definitions of what's being alleged to be alleged in indictments? It seems to me any person with the most basic understanding of the English language would know that if they were charged with 3 offenses as defined in section 924E, you'd go look in 924E and say what's being charged.
Yes, and Your Honor, I think, as Judge Heitens alluded to several times, our constructive amendment argument is harder than Mr. Brown's. I'm not, but the indictment was.
I'd prefer not to use constructive amendment in the context of pleading guilty, but.
Yes, and I would say that our indictment error argument is a harder lift than Mr. Brown. It was still a defective indictment. Different occasions was an element.
That's what I'm questioning you. What was defective about it?
Because
in other
it
words,
did.
you're saying instead of alluding specifically to 924E as definitional, you want the words incorporated.
I want, there needed to be an allegation and an admission by Mr. Boggs, which didn't exist, that they occurred on different occasions. That's what we learned from Erlinger. That's an element.
Isn't that what 924E says?
But Your Honor, just, I mean, you can cite the statute, but it omits an element. 922G on its face always said what it said, but by not alleging that a defendant knew he had a felony status, that turned out to be Rahafe.
I don't want to burn too much of your time on this, but, and the answer, I suspect, is going to be the government forfeited forfeiture. But this all sounds like you think the indictment was defective, and it sounds like you were on, unlike Mr. Brown, though, you had every reason to know the indictment was defective. And so if the government has not forfeited forfeiture, which I think they quite plausibly have, if the government had asserted forfeiture here, it seems that your indictment challenge is obviously forfeited.
And I would say, Your Honor, that at the Rule 11 proceeding.
No, not the Rule 11 violation, but a violation that, because I guess conceptually for me, there are errors in the indictment, there are errors at Rule 11, and there are errors at trial. I'm just suggesting that to the extent you have an indictment claim, had the government not forfeited forfeiture, it strikes me that your indictment claim is obviously forfeited.
And here's why I disagree with that, Your Honor. Whitfield, page 308. And
We'll get to Whitfield.
I guess, because here's why. This isn't like what turned out to be a Rahafe error where they needed to allege he knew he was a felon and they didn't. They alleged a crime. They alleged a completed, for lack of a better word, plain vanilla 922G, to which we pleaded guilty. And I think that is a critical
But then they have the words that say allegations of prior convictions.
They do, and I would say as a practical matter, and I know we can't always think practically, I think that's just boilerplate that's in all of our
No, but it's not in Mr. Boggs' indictment.
But, well, 2 different districts, Your Honor, Eastern versus Western. But let me just, this all goes away, and the much harder question of the indictment error goes away if the government cannot prove that we would, government cannot prove we would have pleaded guilty anyway. And at joint append, you talk about what record is available. What record do we look at? Well, at the time of the plea,
Well, you agree that we look at the entire record, right?
We do, although think about at the time. At the time of the plea, Your Honor, which is the relevant point, PSR didn't exist. And if you look at Joint Appendix 102, 103.
But on the indictment uses the words as defined. It doesn't just cite it as a support. It alleges it as defined. He uses those specific words. And my question is, isn't that enough for an indictment to provide notice and to prevent double jeopardy? I mean, that's really the standard we're looking at in a defective indictment. You're saying there's an omitted element. I don't know if there is. That's what I'm asking you.
So I guess if Your Honor would indulge me, if we assume, I believe the indictment's defective.
All right, you want to presume that?
But assume
Okay.
if obviously if the indictment's fine, then that's it. But
Well,
assume it is
that
defective.
was my question. Okay,
So Joint
let's-
Appendix 102 to 103, we say, Your Honor, several of his convictions, many of his breaking and enterings, my office tried, under North Carolina Raise the Age legislation, which basically allows people to have their prior convictions fully expunged. And we attempted, unsuccessfully because there were some outstanding restitution issues, we attempted, and that's right in the Joint Appendix 102, 103, to make a lot of those go away. All that would have been left, if we had been successful, were the B&Es that occurred in 2018, all on the same day. So at the time of the plea, one of the things Mr. Boggs would have considered about whether to go to trial is the fact that some of these convictions would have gone away. It was unsuccessful. Assuming that's not the case, if we look at his record, he has.
Isn't that the analysis that any defendant does when pleading guilty?
Yes.
He takes a chance, he pleads guilty for whatever strategic reason he's selected, and gives up his right to challenge the allegation, but.
He didn't have the right, Your Honor, to a jury trial at the time on the occasion's different element. If he had, he would have, for instance.
So the argument goes back to what I'd asked in the earlier, is that he was not told that the jury, as opposed to the judge, will decide one element of the enhancement. But the indictment alleges that the indictment puts all the elements before.
He was not told, and it wouldn't have been, if we had said, Judge Dever, we'd like a jury trial on occasions different, Judge Dever would have said, that's not the law, you can't get that. So.
Let me ask you, the indictment charges violent felonies.
Yes.
That is not an element of the enhancement, is it, for the jury?
That is not. That is a question of law for the court.
So is that an error when they didn't tell, when they tell him that not the jury doesn't have to decide that, but the judge?
That is not an error because the judge still, Almendarez Torres is the law and the judge has the power to decide that. But if you look, so here's another reason we'd have gone to trial. Joint Appendix, we're at 161 to 164, paragraphs 30, 31, 32, a group of breaking and enterings, all occurring over a span of about 3 months, all in Harnett County. Then he goes to jail. Then he goes to jail for a year in 2012. Then in 2018, another group of breaking and enterings, all on the same day, all in Pender County. So was there might not have won, but there was a very plausible jury argument that he would have been able to go to the jury and say.
There's a plausible judge argument.
Yeah, a plausible argument that Judge Dever did not buy, but say, Judge, these were two sprees. Your Honor, ladies and gentlemen of the jury,
But you could have made that to the judge of the jury. The question is whether that information, that as opposed to the judge, he knew of the risks of his prior record, and he had counsel. The question is the fact that now other occasions is decided by the jury as opposed to the judge, would that have caused him to change his plea?
Yes, it would have. Listen to what we told the judge. Here we go, Joint Appendix 82, 83. Wooden is a, quote, multifaceted, robust inquiry that suggests it does not matter how close a case may be or whether a court believes it's easy to determine the occasion's different element. There's no hard and fast rule under Wooden that these offenses were committed on different days or even different months, that they are necessarily different occasions. That is a jury argument, Your Honor. That's in the record. That's the argument we would have made.
So is liability on the offense.
Yes,
That's all
but
jury.
I get the
When
question.
you plead guilty, the question is more not whether you had a good argument, but whether he would have pled guilty. That's my
Yeah,
question.
and I
keep
respectfully,
trying to redirect
Your
it.
Honor, I respectfully submit that whether we had a good argument is a huge factor in whether we plead guilty. We would have always, and we did, admit that he knew he had a felony and he knew he had a gun. We would have had a bifurcated trial. The Supreme Court said this can be bifurcated. So what's the downside of going to the jury and either admitting those elements, like literally pleading guilty to those first elements, or stipulating to them?
When they said
and
you can have
having-
a bifurcated trial, did they mean, I just literally don't know. Do they mean you can plead guilty to everything? Can you do like a partial Erlinger plea?
And, Your Honor, if you don't know, I certainly don't know. I think it is to be
Well, I don't know,
determined.
like district courts might have encountered this.
It is to be determined, but I
Other-
think a practical, I think, Your Honor, a practical analogy is capital litigation, where often someone will go to trial and they go to a full trial because they're trying to lay mitigation out
But they
for the
present,
jury.
they don't really
But they
contest
don't
factual
really
guilt.
plead. My practical guess is this may have been a case where we stipulated to the base 924G element, and so that part of, it would have been a jury trial. That part of the jury trial would have been about 5 minutes, and then it would have all been about the ACCA enhancement. But, that means there's much less risk to the jury trial because we're getting right to the nub of it, and then the exposure. If he had gone to trial and won on this ACCA element, which again, he might have had some convictions expunged by then, and even then he had a viable only 2 occasions argument. If that were the case, his exposure at the time was 63 to 78 months without ACCA. And then with ACCA, it's 180 at a minimum to life.
Can I skip to
And
the-
this is someone who'd only been in jail for a year before. So I think he really had every incentive to roll the dice here because of the draconian ACCA penalties and the very plausible jury argument that this was only 2
Can I
occasions.
skip to what I'll call the last harmless error argument in this case, which is the part where the judge said, even assuming I'm wrong about the ACCA, I'm going to give you the exact same sentence anyway. And your response to that, as I understand it, is, but that would affect the maximum term of supervised release he's eligible for in the event that he's later held to have violated the terms of his supervised release. So first question, do you know any court that has adopted that theory of why an error is not harmless?
I do not offhand, Your Honor, although it is a practical burden on Mr. Boggs that has to be remedied now. If we waited until he was revoked,
Why?
that wouldn't be ripe. I mean, this court has multiple cases
But in
saying.
Charles, we've said that whether he violates supervised release is within his own control, and that he should not get credit in an argument that suggests that he's going to violate the law.
In the future.
Yeah, no, and I understand that, but I mean, the question is, we're already operating in a hypothetical world where Judge Devers says, look, even if your guidelines would have been 63 to 78 months, I'm going to have given you over 100 months over that, over double, over double your non-ACCA guidelines, because we're in the hypothetical world now where he is not ACCA, which I actually think he's not, but, from Judge Devers' perspective, I think you're ACCA, no, you're not. So Judge Devers says, I'm going to more than double the top of your guideline range. So just so we know, if this court agrees to us and we go back for a non-ACCA resentencing and Judge Devers does that, I strongly suspect that we're going to be bringing a substantively unreasonable upward variance. I mean, it's very easy for him to say, I would have just given you 180, but justify over doubling the guidelines. So right there, I would say what he's doing is not this little, oh yeah, it would have been the same sentence. It was a heavy lift, but this court doesn't really need to engage in that double hypothetical because I do think that, having this maximum life sentence on him changes his exposure. And, Your Honors, the government, as we point out in I think it was our first reply brief, government never responds to that argument. So I think they've actually waived any response to that argument. They cite an unpublished case from this court that didn't address the question, but they never sort of grapple with that.
Forfeited, right? Not waived.
Yes, Your Honor, again. And I have just about a minute left.
Can I ask you a remedy question? What is
Yes.
the remedy you're seeking?
So, Your Honor,
Because I thought I just heard you say you're seeking resentencing, but why wouldn't the remedy be withdrawal of the plea?
and I think, Your Honor, that I guess I would say the remedy is resentencing if this court were to agree that it was indictment error. Under Whitfield, I know Your Honor say it's not a constructive amendment, but the indictment was so fundamentally defective. He pled to something with a max of 120.
I just say the reason this.
So if Your Honors, though, agree that the question is, would he have pled anyway, which I think is our strongest argument, then yeah, I think we go back, we blow up the plea, and we actually have this jury trial. Which this isn't, we come up here, oh, we would have a jury trial, it's harmless, or, and then we go back and plead anyway, and everyone wonders how disingenuous I was being. I mean, I just laid out 5 reasons he would have gone, and again, this is someone who was, if he wins at the jury trial, the top of his guidelines are 78 months. And if he goes to trial and loses, perhaps, if he were to testify or something and Judge Dever were to find he was obstructing justice, there is some risk, but, he's at 180 and he probably ends up at 180 whether he goes to trial or not. Yes,
So
Judge Floyd.
follow up on Judge Hyten's question, if we were to agree with you, are you gonna go back on a trial on the whole thing or just the enhancement issues?
May I answer, Judge Niemeyer?
Please.
Yes. Judge Floyd, I can't speak, I can't entirely predict our trial strategy, but my guess is that the plea would be vacated, we would go to trial and most likely stipulate to, or at least not practically contest, the knowing possession of a gun, knowing we had a felony.
Well,
And we would contest the heck out of the occasions
Are you-
separate.
Are you ever gonna be able to are you ever gonna be able to plead guilty just to the underlying charge and then have a jury trial on the enhancement issues? Can the government be
I-
forced to do that?
And I don't know. I think that will be developed over the post-Erlinger months and years.
Well, you can't do it on drug quantity right now, right? If you're an 841 defendant, you're not allowed to say, I definitely admit that I definitely had
Yeah.
drugs and I definitely admit all these things. I just want a jury trial limited to the question of how many drugs there
Yeah,
were.
and so I think the cleaner way to do this may be trials where things either practically aren't contested or are formally stipulated. I would also, if I may just, and maybe Mr. Bragdon will have a sense, if this court does vacate the plea, I suspect the government will supersede with an indictment that
And fix
does
the Erlinger
allege,
problem?
that fixes whatever indictment errors may be there. Thank you.
And it's still gonna go to trial? And it's still gonna go to trial?
Your Honor, I mean, it will be his choice up until, the day of trial, but I'm one of his lawyers, and I would advise him to go to trial on occasions different because I think it's a winnable jury issue in his case.
All right,
Thank
thank you,
you.
Mr. Brainiac. Mr. Bragdon?
Good morning. May it please the court. I'm David Bragdon, and I represent the United States. I want to hit a few different things. I do want in a minute to discuss some of the facts and the strength of the evidence. But before doing that, I would like to hit the legal standard that we consider here in harmless error. And also, to the extent the court is interested, I do have some thoughts on both the grand jury and the Shepard documents issue. The court has been talking a lot, and counsel has been talking a lot about whether or not he would have chosen to plead guilty. And as far as I can tell, based on my research, there have been 8 circuits that have addressed harmless error in a guilty plea context, and none of them have applied that standard.
Has any of them explained why they're doing this jury question? With no disrespect to anyone, it strikes me that in many of these Apprendi cases, like, there's the jury issue, there's a jury Apprendi violation, and then like, oh yeah, there's also this indictment problem. But the cases end up getting driven by the jury problem, like Nader is an example like that. And I think the follow-on to Rahafe is one of those. Like, I agree with you, I've seen those cases, they say that. I don't see a single one of them explain why that's the right question.
I don't either, Your Honor. However, I do have an explanation.
Okay.
That I've thought about at least, which is defendant here and defendant in these other cases did not ask to get out of their guilty plea. And I think that's a distinction that you have between Greer and these other cases. What they want is a resentencing. And I think when they want a resentencing without ACC status. It would be very odd to say in one set of circumstances, okay, we're going to consider whether you wouldn't have gone into trial, and the other set of circumstances, we're going to look at whether the evidence is uncontested or overwhelming. Those situations really at sentencing stage are exactly the same. And so to me, that is still the appropriate standard. Now,
What if the defendant says, I want to get out of my guilty plea?
Then that's not this case.
No, I
I think
understand.
that could change the analysis. I think if defendant
But
came.
isn't the analysis here whether he would have pled guilty?
Well, defendant is not seeking to get out of their guilty plea, and so these other circuits that have applied it, even in the plea context, have looked at whether the evidence is
But
uncontested
the
and
case
overwhelming.
ends, basically, the guilt phase, the whole notion of Erlinger is that it is an element of an enhancement that has to be included in an indictment. And when you plead guilty to the indictment, if you're not aware of that, then you change your plea. But I must say, I had a lot of difficulty conceiving why we're going to sentencing, which presumes the guilty plea's in place. His argument is that he had a Rule 11 dialogue and wasn't told that he could go to a jury on an element of the enhancement. He also contends that the indictment didn't include sufficient information to tell him that. Now, it seems to me the only relief he could claim on that is, I want to plead guilty again. I want to have my guilty plea removed and consider whether I plead guilty to the indictment. And then, as Judge Hyten says, at that point, the government's going to add a few words to, instead of as defined by 924E, it's going to say 3 other occasions, on 3 different occasions. I don't know where we're going on this. He knew he was facing this. The question is, who's he challenging it before? And the argument has to be, based on his argument, I think, that if I'd known I could go to a jury on the 3 different occasions issue, I would not have pled guilty.
I do understand that way of looking at it.
But I don't understand the other way.
The only thing I'll say is the other courts that have considered this and other circuits have looked at it the other way. And I guess what I would say is.
Well, that goes to the fundamental issue of Erlinger. In other words, it's a little bit different to take a sentencing enhancement based on recidivism and say judge finds part of it and a jury finds another part of it. That's the Supreme Court's case, I understand it, and that's our law. But it does create complications because it is basically increases the sentence, not based on the conduct charged, but on past conduct. And the Supreme Court has said because it increases the penalty, it goes to a jury. Well, a lot of other things increase the penalty also that don't go to the jury, but you know, I'm not criticizing. I don't want to be criticizing. I'm saying it's making it complex. But I can't understand why we're focusing on the sentencing if the argument is he wasn't indicted correctly and he didn't understand the charges at his plea.
I do agree that it's a guilt phase determination. And I won't belabor that difference because like my colleague in the U.S. Attorney's Office, I think we win under either standard, whether the court analyzes whether this defendant would have pled guilty or whether it analyzes whether it was uncontested and overwhelming. And I think the key fact here
Well,
is.
that uncontested may go into the analysis as to whether he would have pled guilty. In other words, if he's facing very clear evidence, he could not make a good argument that a jury would give him a greater benefit than a judge finding those facts. If it's close, he might be able to make that argument. You know, jury's 12.
Yeah. I think it absolutely does, and I think the biggest fact here is at no point in district court did the defendant say, my crimes did not occur on different occasions. They all occurred on the same occasion, or you didn't prove 3. That was never an argument. What he argued instead was this is a jury issue and it should have resolved by the jury. But he never.
We're talking about a limited number of cases now because the government's going to comply with Erlinger in the future. Why should we change our analysis of harmless error to something else now when we're talking about a limited number of cases? And they were prepared to plead guilty to the underlying charge. They just didn't know about these other things. I'm just a little perplexed about what we're doing here?
Thank you for that question, Your Honor. So let me just say, first of all, I guess I will say I don't think it's changing the analysis because I think this analysis comes from Liggins. I think it's consistent with Supreme Court cases like Greer that analyze substantial rights. But secondly, what I'll say is in this limited set of cases, there is no way to turn the clock back. Short of letting the defendant out of the plea, there's no way to turn the clock back to what would have happened beforehand. If we say, well, armed career criminal just can't apply because the government didn't charge it or prove it at the time because the law was different, well, then that's a situation that would not have occurred. And if we say, and so what the court says, the court has applied harmless error in these situations, and they apply it. They recognize that this is a little bit of an infringement on the jury right, but that's why they set such a high standard, beyond a reasonable doubt. And at least in the trial context, beyond a reasonable doubt means no rational jury would have decided it defendant's way. And I think here, where it's uncontested, the occasions occurred, the crimes occurred months first and then years apart between the kind of, here we have sort of three, I think of them as three sets of crimes. Set one, Harnett County, you have another set a few months away, also Harnett County, and then you have another set a few years away in a different county. I think there's not much question on the second and third set. But even between those first two sets, you have different victims, you have dates months apart, and you have different things taken in the burglaries involved. And so it's not a close call. And recognizing it's not a close call, even in defendant's opening brief, even in the reply brief, they didn't argue, hey, these were committed on the same occasions. It was the sir reply where they first tried to make that argument. And so this is not...
Sort of like your forfeiture argument that doesn't show up until your sir reply brief?
Well, so, yeah, I would say so. Now, to be fair, to split hairs a little bit, the grand jury argument that these weren't in the indictment, I think that shows up for the first time in the sir reply brief. That was not raised in their initial brief or their reply brief. And so to the extent that this is a grand jury issue, I think that we don't, that's something that was not raised. I did want to briefly address the grand jury issue, and I just want to say that, first of all, there are other circuits that have applied this harmless error, both in the context of the grand jury error, and in particular, Confredo from the Second Circuit, Pena from the Second Circuit, and Harkely from the First Circuit. The second thing I will say is...
On the grand jury error, but the Sixth hasn't?
I don't recall, I did not see the Sixth Circuit case, at least the one that we cited in our 28J letter. I didn't see it addressing that. I may have missed it. The second thing that I'll say is Liggins is a very close factual case to this. It's much closer, I think, than Whitfield. And for a particular reason, when you talk about a constructive amendment to the indictment, you're talking about something that was changed from the indictment to presentation to the jury. And that's what happened in Whitfield. You had the judge giving an instruction that is different than what's in the indictment. Here, there is no jury, and so that difference does not exist. And to the extent the court thinks, well, it doesn't really make sense to treat that factual difference differently, I would say that the trend in Supreme Court cases is to find that substantial rights can be analyzed even where there is a problem in the indictment. And I think Washington v. Requencio didn't directly address this issue, but at
Because the
least.
court literally says we're only talking about a jury error here.
It did, but that case, it was not charged in the indictment as well.
Sure, but the court literally has a footnote that says we're not talking about any indictment problems.
And then Greer is another example where it was not charged in the indictment. And sure, it's plain error, but the substantial rights analysis is the same kind of substantial rights analysis you analyze in harmless error.
Except as your friend says, Cotton rather conspicuously gets to substantial rights and goes like, there's like a hard question here about this. Who cares? We're getting prong four. The prong four, all, you know, defendant work. We get to prong four and the defendant loses, right? Like Cotton, it'd be really helpful for you if Cotton had been resolved on prong three, but Cotton is very clearly resolved on prong four.
But Greer was resolved on prong three.
Sure.
And Greer would have been a very different opinion if the Supreme Court had said, hey, this substantial rights prong can't be analyzed under a prong three. It's automatically a met, you know, and so that's a different opinion. And so my point is, when you have Liggins that directly supports our position, and it seems to be consistent with the modern trend of Supreme Court opinion, I don't think it makes sense to take another case, Whitfield, that doesn't directly address our situation and expand it and take it kind of beyond its immediate context. And so I would suggest that this court should follow Liggins. I think Liggins is not inconsistent with Greer. I think there's tension between the two approaches, but I think that tension, I think that the Liggins is much more consistent with modern Supreme Court jurisprudence than Whitfield is. And so I don't think it makes sense to say, okay, we're going to essentially find that Liggins is foreclosed by Whitfield. I wanted to briefly address the Shepard documents argument. One of the things that defense counsel said in this case is that you should not, you can't look at Shepard's documents. And I would just say, you know, as a factual matter, what the Supreme Court said in Erlinger is, hey, these documents, these Shepard documents, they aren't so infallible as to avoid going to a jury. They're not that good. But it never says you can't use them. And I would imagine even in 922G trials, Shepard documents is exactly the sort of evidence the government often uses to prove the defendant knew he was a felon, which is an element we now have under Rahive. And so those sorts of documents.
When you say the government uses those documents at trial, tell me what, we don't introduce PSRs at trial, right?
I agree, but this is an admissible form of evidence. And so.
Well, no, that seems like a really, if by Shepard documents you mean like judgment of conviction for the previous, sure, totally get how we do that. Transcript of guilty plea colloquy in your previous case, I get that. But the government doesn't get to admit PSRs before juries, right?
That's correct, Your Honor.
Doesn't that seem like a pretty big and important distinction?
I think it is a distinction, and I'll talk about that in a minute. In our case, we did have Shepard documents. We weren't relying on the PSR here alone.
Wasn't the PSR part of the record?
But the PSR is part of the record, and the court has said.
In Greer, didn't the court actually refer to the PSR as part of the record?
Absolutely, Your Honor. And in fact, in Greer, the court specifically said, hey, when we're analyzing substantial rights, we're not limited to what happened at trial. We're able to look at any part of the record. And it's because we're analyzing this counterfactual. We're analyzing what would have happened had this been proven, and presumably the government would have presented this evidence that it had it been proven. And so the court looked at the PSR. I think there are other cases and certainly other circuits that have equally applied Shepard's documents and looked at those documents. And so I think that in considering.
Can you address just briefly what your views are as to whether there was an error in the indictment?
So, Your Honor,
You alleged in the indictment, I'm probably asking the wrong person, but in the indictment you alleged as defined to buy. you said three prior convictions as defined by, and then you gave the citation which gives all the aspects of it.
I would, I hate to make any concession. I do think that we made an error in the indictment. And when we say as defined by the statute, I think what that meant is these are violent crimes within the meaning of how the statute applies violent
But
crimes.
it also defines in the same definition on 3 different occasions.
It does, and so maybe it's not a violation. I think
mean,
I,
the violent crimes is a long definition. It's 2 or 3 lines long. And the question is, do you have to put violent crimes and then put the statutory definition in? And you're saying that you don't have to put that in, but you have to put on 3 separate occasions, both of which are defining the qualifying qualifications.
I would certainly say the best practice is for us to allege that they occurred on different occasions. And in other cases, the court has said sometimes a statutory reference is not enough to
It's not a reference,
include
that's
in-
my point. You actually alleged as defined by. And so it's not a citation to support it. It's a definitional. You're instead of saying, put in the full definition of violent crimes and on 3 separate occasions, or different occasions, and of course, 3 different occasions can be defined too. I mean, then you have to start going into wooden and trying to distill something from wooden. I don't know how far, I'm a little surprised that you haven't rested more on that, because it seems to me the requirements of an indictment, if you go back to the fundamental rule about what an indictment is for and the essence of an indictment, I've understood it, I haven't gone back and looked at this, that it's to provide notice and to prevent retrial on the same, on something similar. In other words, to distinguish it from, for double jeopardy purposes. And it seems to me that when you say 3 different crimes as defined by 924E,
May I answer?
please,
I'm about out of time, but that may be an argument that we missed here.
no, it's all right. I'm not causing you to embarrass you.
I think
thought
it could have been more clear, certainly. Maybe it was good enough, the way it was phrased, but that is not an argument we made in our briefs here.
Can I ask one other thing? As in the first case, I believe in this case, neither defendant contested the accuracy of the prior convictions. Is it necessary for us to go in this opinion and address the Shepard issue?
So I would say,
In other words, would we be giving an advisory opinion if we?
maybe it's not necessary. That's a good point. The defendant never did challenge the accuracy. The defendant never challenged the accuracy of the dates either. This one is also a little unusual because the Supreme Court does express some concern of, okay, a date could be wrong. Here, you have quite a few, you have 12 separate convictions, many of them occurring on similar dates, and so multiple of them would have to be off for that to be a real argument in this case. So,
All right.
if there's no further questions, I would ask the court to affirm in this case.
Thank you, Mr. Bragdon. Mr. Bringat?
Thank you. So to get to your concern, Judge Niemeyer, about the indictment, wait until oral argument rebuttal to look at the statute. But the indictment says, violent felonies as defined in section 924 E2B. That is the violent felony definition. E1 is the different occasions allegation. So I think as right on the face of the indictment, it does not allege different occasions. I also really want to get to, I think, correct something my colleague just said, that we never contested that they were on different occasions. I mean, I read it once before, I won't read it again, Joint Appendix 8283. We said, I guess I will read it to a small degree, these offenses, Wooden says that just because they were committed on different days or even different months, that they were necessarily different occasions. And then then the government submitted Shepard documents. And Judge Dever at the sentencing went through the Shepard documents to say, I see these addresses, I see these dates, I find there are different occasions. So it was totally contested. The error is that it was Judge Dever and not 12 honest people sitting and making that determination.
Can I
And
ask you about what now is starting to appear to me as a significant right remedy problem? So I just glanced at every brief you've submitted to this court, and every single one of these briefs ends by saying, you should vacate and remand to give me the lower, better sentence, and not a single one of them ends with, you should vacate and remand for resentencing. Why isn't that a real problem? Because I'll just say it, I think it is transparently obvious the remedy here is to vacate the plea. It is not to give your client the better sentence.
And Your Honor, I think what happened here is, we sort of had two cases. It's not like we all weren't aware of Rico Brown and Trevor Boggs. The Supreme Court kept deciding things. It went up to the Supreme Court. Brown was GVR'd. This court initially remanded, and then.
That's why you guys are paid so much.
Yeah, well, and so I guess as this has evolved, I was asking for my maximal remedy, which was he pleaded to a base 924C with a cap of 10, and he was sentenced to 15. And so my maximal remedy was give me the lower sentence.
Okay, but lots of lawyers ask for alternative remedies.
Yes, well, and the government itself, Your Honor, in their briefing, cited Haywood, so that was there. I was saying we deserve a better remedy than that, but I think inherent even in the government's briefing, which again cited Haywood, which I think is the case that controls. And look, if I had this to do all over again, I think I could have asked for that as an alternative remedy, but
it's not
effectively
even
that's what the
logical.
government was.
It's not even logical, because if the indictment was an error and the colloquy pleading guilty to the indictment was an error, that's where the error occurred. The error didn't occur in sentencing, it occurred in
I think you're-
pleading guilty to when this should have gone to a jury.
And yes.
So it seems to me the only remedy is to do over the Rule 11.
I think you're right, Your Honor. I think as we have had this conversation and we've been here for a couple hours now, I think I have come to that position. The other one more thing I want to say, and I think this was so inherent we didn't really say it. The reason for a lot of these cases that defendants are going to choose to go to trial in these Erlanger cases is it's a rare instance where you're going to trial on your punishment. Normally, the question is, you're charged with a crime, it has a punishment. Would you have pleaded guilty or not? And then, well, you would have lost acceptance of responsibility, there's aspects. Here, it's kind of like a bit of a have your cake and eat it too, at least the way the Supreme Court's laid it out, of, yeah, I'll plead guilty to the thing I'm obviously guilty of, but I'll take my chances to go to jail for 90 months instead of 180. And so I think this problem will go away, the harmless error, but, I think there's going to be a lot of Erlanger ACCA trials.
There's no question about it. It's going to cause the district courts, it's going to create a need for them to design some way, and the attorneys to design some way to handle this. Bifurcation may be one way. I don't know if you can fracture a trial and go on part. You'd probably have to do the whole thing and just stipulate somehow. And then you have stipulation problems under the Constitution. I think you're absolutely right. We're going to see you again, and we're going to see Mr. Bragdon again.
And Your Honor, it's example number 327 of why I'm glad I'm not a trial attorney. And I think the court, and we would ask to vacate, and I do think at this point ask for the opportunity to have a proper Rule 11 with a proper indictment. Thank you.
All right, we're going to recess, take a short recess. Before then, we're going to come down and greet counsel, and if you would come up and allow Judge Floyd to greet you here too.
This honorable court will take a brief recess. Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
All right, be seated, please. All right, the next case we'll hear is United States versus Williams.
May it please the court, good morning. I'm Edward Yeager of the North Carolina Bar on behalf of Mr. Williams. This criminal case has a lot of history. It actually goes back to charges in 1998 and a conviction in 1999. I obviously won't go through that history. I would just highlight that it included part of his conviction being reversed by the Ninth Circuit, and then ultimately his judgment was amended to time served during the COVID pandemic. What brings us here today was what occurred in his supervised release hearing in 2023. The probation officer in Mr. Williams' case filed a violation report on March 10, 2023, charging new law violations, alleging that Mr. Williams had assaulted the mother of his two children and his on-again, off-again girlfriend with whom he was living at the time of that. The case actually came to court on November 23rd, 2023, so it was some 8 months later. Despite that lapse of time, the government did not have as a witness the girlfriend, the alleged victim of the assault. They also did not explain why she was not present, and they were not able to show efforts they had made to locate her. Instead, they put on for testimony the Durham police officer who had taken her statement, as well as the body cam footage and written statements. Our position is that under Rule 32.1, which states that a person is entitled to question any adverse witness unless the court determines that the interest of justice does not require the witness to appear, that the district court erred in its finding of good cause by the government. This court has said in a number of cases that the standard requires balancing the defendant's interest in confrontation against both reliability of the out-of-court statement, as well as the government showing good cause for the witness not being there. Here, Judge Whitney correctly stated that standard. He used a balancing test, but we submit he erred in finding good cause. Judge Whitney stated that he was relying on U.S. v. Callan as highly useful. Judge Whitney's reliance on Callan was misplaced. He said, and I quote, "It's a case very, very similar to the facts of this case," end quote. Later, he said, quote, "The Callan case, as the government points to, is a case that the facts are extremely similar to the facts in this case," end quote. Callan is an unpublished decision of this court from 2021. Later, Judge Whitney quoted Callan, and the direct quote from the unpublished opinion in Callan is, quote, "The government worked with local law enforcement to try to locate the victim for several weeks. The victim could not be found, so the government could not call her as a witness to testify." That's the direct quote from Callan. There's not much other explanation in the Callan opinion. In the transcript from the Callan case, I did find this statement from the AUSA. He said, quote, "The United States has tried to locate her and has not had any luck in locating her. We spent time through the weekend where I had local law enforcement officers also try to locate her and was not able to locate her." We would point to his distinction in Callan is that at least the government made efforts to locate their witness before the hearing. In this case, the government's good cause came down to some efforts made after the first hearing and after the hearsay objection was raised. When they came back, and remember what Judge Whitney did was he ordered the parties to brief the issue. So he took testimony from the Durham police officer on November 8th, had the parties brief the issue, came back in January of 2024, at which time he reviewed the briefs and heard from the probation officer, and then he ruled that all the evidence which he had heard was admissible. So when the parties came back in January of 2024, they put the probation officer on. She testified that she last spoke with a witness on March 8, 2023. the government asked about the efforts to locate the witness. All of those efforts came after the case was called for its first hearing. The probation officer sent a text message. She called and left a voicemail. She sent an email. And then finally, she went to the home on December 12th. She also testified that she tried to use the Durham Police domestic violence detective Baumgartner, that he called and left a, quote, nonchalant voicemail for her. Unclear what a nonchalant voicemail is. In summation, the government said she simply stopped returning calls. She's moved away and we have no way of finding her. And she does not seem to want to be found. Well, what we would submit is there's no evidence that the government made any calls for her to return to them for 8 months or more. In terms of moving away, the only evidence is that she was not at the same address. She could have been living next door. And when the government said she does not want to be found, well, it's really law enforcement's job to locate individuals. And here, we see no investigative tools being used. Also, there's nothing in the record that the probation officer told the witness that after the violation report, there would be a hearing and that she needed to stay in touch with him. Later on, after the judge had allowed the testimony, found the violation, and moved to sentencing, the AUSA said, there's a reason why she's not here, and we would suggest that it's because she's afraid. That may very well be true, but there's nothing in the record to support that statement. There also is nothing in the record to suggest that the victim knew about the court date or that she even knew there would be a court date that she needed to stay in touch with him for. As I said before, in the Callan decision.
Can I ask you, what else do you think the government should have done here? Or was required to do? Not should have in the sense of going to the ends of the earth, but what do you think is the minimum additional thing they would have needed to do to allow the district court to find that they had made reasonable efforts to locate her?
I think the simple case would have been if the probation officer or any other witness were able to testify. We took a statement from her. We informed her that the court process would be, we're filing a violation report and there's going to be a hearing. And we may need you to testify, so please stay in touch with us. Give us a phone number where we can reach you.
And then they call that phone number, and she doesn't stay in touch with them. They call that phone number, it doesn't work. In that situation, do you think that would have been enough?
Well, honestly, it's hard to say because people can change their numbers for numerous reasons. If the government had made any efforts before 8 months had passed, I would say that probably rises to the level. But ignoring it and basically whistling past the graveyard until well past the hearing starts, I would submit is legally insufficient.
Well, can I ask you, so this bottom line comes down to the government's essential assertion is we don't know where she is. Right? That essentially the argument is we don't know where she is. What's your best authority for the proposition that if the government says we genuinely don't, we've tried to find her, now we can debate of whether we've tried to do enough to find her, but we've tried to find her and we can't find her and we don't know where she is, that's enough, right?
Well, there's limited authority on that question,
Right,
Judge
sure,
Hyams.
totally agree.
And it's more or less for the court to determine after hearing what those efforts are.
Sure.
We would just submit that in this case.
But I
those
guess I would
efforts-
say just like, for example, under the confrontation clause, I'm thinking mostly of Ohio versus Roberts here, like, we tried really hard to find them, again, bracketing whether we tried hard enough, but we tried really hard to find them, and we can't find them, is sufficient to render a witness unavailable even when the Sixth Amendment right applies, right? And so it seems a fortiori that in this context, where there is no Sixth Amendment right, and your protection is much weaker than it is at trial, if that's good enough to satisfy the confrontation clause, that has to be good enough to satisfy this rule, right? We tried really hard to find them, and we just can't.
I would agree if you tried really hard
Okay,
to
sure.
find
So
them.
now we're just debating whether they tried hard enough.
Yes, sir, that's
Okay,
correct.
okay.
And I think that would be up to the district court judge to say, okay, what do you mean when you say you tried really hard to find them? And as part of that discussion, we would submit that when those efforts occurred also mattered. Because if the government does not maintain contact with what is an essential witness for many months, it becomes much more difficult to find that witness. And at that point, I would submit more efforts are required to locate an individual.
Well, assume that's a really, really close question. It probably is. But doesn't the judge have the ability to determine the reliability of that hearsay statement? For example, in this case, she gave statements to two different detectives. Their stories jived. She took photos. The police took photos and they jived. Why doesn't that make her statements reliable and admissible in a close call of whether they made a good effort to find her?
Because under several cases, including United States versus Ferguson, this court has also said that the court must find good cause for the government not having that witness available.
Oh, I agree with you on that, but assuming that question is really, really close,
Yes,
which it is, does the judge not have the right to evaluate the reliability of that hearsay statement and admit it if he believes it's reliable?
Yes, Judge Floyd, I would say he does have the right to, and the obligation to evaluate the reliability of that statement. We would say also, however, that if he does not properly find good cause for the witness not being available, the reliability will not get him past that test. So our position is that Judge Whitney correctly stated the balancing test, but he misapplied it.
So just so I understand, and I think this seems right to me, but I want to make sure this is what you're saying, is that there is a baseline, that I think we have a case that says this, right? Like, it does not matter how reliable the statement is if there's no good cause whatsoever, right? Like, that these are separate requirements, that you have to make some good cause to not find the witness, and even the most reliable statement in the world is inadmissible, absent a showing of some efforts to locate the witness. And I suppose the other side is also true. There has to be some minimum baseline of reliability because, among other things, the Due Process Clause forbids you from admitting fundamentally unreliable evidence, right?
Yes.
And so there's minimums of both of those, and if you don't hit either minimum, we're just done. Once you hit both minimums, we can sort of trade them off against each other a little bit as long as we're over the minimum threshold for each. Is that broadly how you understand how this test works?
That would be reading a lot into the case law, which is not there.
Totally agree. Perhaps that's why we're having this argument today,
that
because
might-
there's very little case law on this.
That might be a fair argument, but then you're creating a separate balancing test between reliability and good cause.
Sure.
And how do you weigh those out? I would submit if.
There is a little, how do we decide if these apples outweigh these oranges, which is a fair question, but it seems to me that we've kind of said that, right?
I think the case law.
I don't know what balancing test means other than that.
Well, but it does, but it speaks of the balancing test between the defendant's right of confrontation versus the government's obligation to show reliability and good cause.
Well, do you think reliability is part of, like, I mean, it can't just be, the defendant always has an interest in confrontation. I mean, like, at some level, that's a little confusing to me as well, because the defendant literally always has an interest in confrontation. So it can't be that. Why isn't reliability sensibly thought of as part of the defendant's interest in confrontation? As in I realize that we have completely repudiated this approach in the Sixth Amendment context, but we used to do this approach in the Sixth Amendment context, that the more reliable the statement, the less the need for confrontation.
I'm not sure of a good reason to answer that, except that Rule 32.1 requires it. And also, when you look at the specifics of this case, what are we speaking about as reliable? We have a body cam video evidence, so we certainly believe that's reliable. Right. Statements that were made by the purported victim of domestic violence, however, were not subject to cross-examination by the defendant. He raised a defense that perhaps he was not the perpetrator of domestic violence in this case. There's really no way to get to that.
It's not hearsay, is it, where she files a complaint with the police or calls the police, and that's direct evidence that they can respond to. And they also viewed her physical condition. That's not hearsay, that's direct evidence that they can testify to.
Yes.
They can't testify to what she said or her explanation, but it seems to me there's a lot of independent, non-hearsay evidence that doesn't even need reliability. Well, all evidence needs reliability, but that could be considered direct evidence.
Yes, Judge Niemeyer, we would agree that
Yeah.
that there is that amount of evidence that's in the case that Judge Whitney had to review and to determine. Our position in the end, though, is that the efforts the government made to locate the witness were too little and too late. And we would ask this court to follow its holding in Ferguson and other cases that unless the government makes a showing of good cause for why the relevant witness is unavailable, hearsay evidence is inadmissible at a revocation hearing. We would ask you reverse the district court's order.
All right, thank you, Mr. Yeager.
Thank you.
Mr. Guino? Mrs. Guino, excuse me.
May it please the court. Elizabeth Greeniff on behalf of the United States. The district court acted well within its discretion in admitting the victim's statements at the revocation hearing. And I'll turn to the good cause standard first. I have plenty of evidence of reliability, but I think where we're differing perhaps is over the good cause.
Because you agree that our existing authority doesn't establish a lot very clearly, but one thing it establishes very clearly is, right, no matter how reliable, absent some showing of good cause, you can't admit this evidence.
That's correct.
Okay.
Because Doswell, Ferguson, and the Woods case, I believe that he cites, in all three of those cases where it was sent back, there was no evidence at all put on of good cause. And here, of course, we did have evidence put on of good
Can I
cause.
ask you what I'll call the timing question? Is, based on the record, is it in fact true that there's no evidence the government ever attempted to contact this witness until after he objected to admitting her out-of-court statements against him?
So based on the record, I think it's ambiguous, but I do think that there are indicators that would show there were earlier efforts made. When the prosecutor asks the question, what efforts have you made, he couches it in, since you spoke to the witness in March. And then there also is the statement that he says, I informed defense counsel prior to the hearing that the witness would not be here. So that to me provides some indication that there were efforts to contact her earlier.
But the things you just said, those are your two best support in the record for the possibility they tried you before?
That's the support in the record, yes. And you can tell from what the probation officer did, she tried texting her, she called her, she left a voicemail message, she talked to the domestic violence detective and obtained an email, she tried emailing her. And when none of those efforts worked, she actually went to her last known address. And again, someone else was living there, said he'd been living there since July, had no idea who the victim was. And so the government decided, this is what, we can't locate her. We've tried, she will not return any messages. We don't know where she's at.
Can I ask you the question I asked your friend on the other side, which is, how do you think this standard for unreliability or good cause here relates to the constitutional standard for unreliability? Like, it seems obviously that it's not a higher bar than the constitutional standard, but I assume you think it's a
No.
lower standard, but how much lower is it than what's, well, I guess, I assume you don't think it's higher than the Sixth Amendment unavailability.
Definitely not.
But if it's lower, how much lower, you know what I'm saying? Like,
In terms of availability or reliability, I thought.
availability.
Availability.
And I guess I'm gonna, the strand, I mean, there are some unavailability cases that are easy, like the declarant is dead, the declarant is in a coma, but I'm talking about the Ohio versus Roberts. We tried to find them and we just can't find them. That strand of unavailability under the Sixth Amendment.
Right.
How does this standard under this rule, in your view, relate to that strand of Sixth Amendment unavailability?
Well, I think it's a lot lower because, as the court said in Doswell, this is not a Sixth Amendment right. Here we're at a supervised release revocation hearing. It falls under due process, which is Rule 32.1. So it is a lower standard, and the federal rules of evidence don't apply. So Federal Rule of Evidence 804 talks about unavailability,
So it's also lower than,
for witness.
also lower than that.
Correct,
Right.
yes. So I think there is not a lot of authority on where that line is, but we know from the cases where it's not done at all, that's not good. And I haven't really seen much in the way of these efforts weren't enough. And if you look at the case law, you'll see the Second Circuit's decision in Pogero, which says even if you can find the witness, if they don't want to appear, and it happens a lot in the domestic violence situation. These are witnesses who are afraid, who have had a long history with the defendant, and it's asking a lot for them to come in for these. So
So
if,
for example, but this leads to the obvious, like the witness doesn't wanna. If only the government had ways of making people who don't wanna do things do them. Except
Right.
the government does. So do you have to subpoena them? I mean, like lots of people tell lots of people they don't wanna do things.
correct, yeah. And so the issue here isn't whether we could have done more. I think the issue is, what were we required to do? Did we do as much as we needed to? We didn't know where she was. It'd be really hard to subpoena her without
Or
an
be an empty
address.
gesture. You can subpoena cool, you can do that, but that's not gonna really fix the problem that we don't know where
Right.
she is.
Right, and in cases where, I think it was the Martin case from the Eighth Circuit, where they did in fact subpoena the witness for state court, and she refused to, she showed up at court but refused to testify. And then when we were calling the same witness, the government, for the revocation hearing, we said it would have been futile to bring her here, and the Eighth Circuit said that was fine.
Because she already previously refused to testify in state court.
Correct.
So you brought up the domestic violence. How important is it to your argument on good cause that this is a domestic violence case? Because I'm just trying to figure out how much the nature of the underlying offense or alleged offense intersects with good cause. Like, is that a suggestion that you can spend less efforts trying to get domestic violence victims into court, or is it that the fact that you were unable to do so is more likely to not be a problem? You know what I'm saying? Like, let me just ask the first question. Are you suggesting that it means that you can have less efforts because it's a domestic violence case?
So I think it's one of the factors the courts should weigh. It's obviously the court's,
Why?
in the court's
But wait, so
discretion.
the nature of the crime affects, or the alleged crime or the alleged violation affects how hard the government has to try?
No, I think it's what, the role of the witness that they're trying to obtain. So I think, and I guess to some extent it could be the nature of the crime, but really I think in this situation, that's why we don't have a lot on this, because it's something that's within the broad discretion of the district court to balance those factors out and figure, in this situation where we know this woman was strangled and thought she was going to die, and she hasn't kept in touch with the probation officer or appeared, and she's moved, we should not be requiring the government to do more than it did here. And I do want to talk a little bit about the reliability information, because that was very, very strong here. And I think you were asking before about if there's a lot of reliable information, does that mean perhaps there would be a lower standard in terms of showing the good cause? And I do think originally the rule required just a showing of reliability, and then later on it was amended to include the showing of good cause as well. So I think that also plays a role
Well, that's a
here.
Morrissey issue, right?
Correct, yes. So the district court properly found there was very reliable evidence here. I think Judge Niemeyer, you mentioned there's a video of her statement. The court could look at her demeanor in that statement. There's also photographs that she
Because
took.
her demeanor is not hearsay. Like how she's
Correct.
behaving is not hearsay.
Right, yes. She had the photographs, the metadata showed those were taken the date of the incident, the ones that she took the day after. The police took more photographs. I also want to mention that there was an outstanding warrant that the probation officer found for Mr. Williams' arrest regarding another assault that involved grabbing a woman by the neck. So there is that independent evidence. And I know he tries to suggest that perhaps her husband could have been responsible for this. But one, there was no evidence before the court that her husband was ever around. And two, when he did, before the court made the reliability determination or the admissibility determination, and when Mr. Williams testified regarding that, when he did enter his own testimony, he said that he had heard that the husband might be in town, but he had never seen him. And of course, there was no evidence that the husband would have been violent. So if there are no
Okay.
further
thank you. All right,
questions, thank you very much.
Thank you. Mr. Yeager?
Your Honors, I won't belabor what has been said. What I would submit, though, is when we talk about those efforts, when the issue of issuing a subpoena comes up or anything else, that wasn't done here. And when we go back to the idea of what the minimum should be, I would submit that when the probation officer talked with the victim, there probably would have been some conversation that we're going to issue something to revoke his probation. There's no evidence that the victim was ever told, we might need you in court. We might need to stay in touch with you.
What about the statements that your counsel, Ms. Greeno, suggested where you were told he wouldn't be available and that those statements she alluded to that indicated prior efforts to discuss with the witness and get her to the hearing?
Yes, sir, and I heard her say the record is ambiguous, but that they're indicators that the defense counsel was informed. I'll be honest, having read the record several times, it was not clear to me from reading it that they put that on record, that they had made efforts to locate the witness and that she was.
No. I think she agrees that it's just by
Yes, sir.
implication. Yeah.
Yes, and I think that's the best that we have. Thank you, that's all.
All right, thank you very much. We'll come down and greet counsel and then ask you also to approach the bench and greet Judge Floyd. Oh, yeah. Yeah, Mr. Yeager, you're court appointed?
Yes, sir.
I really want to express our appreciation for that service. As you know, it's very important to us and for the whole community, and you did a fine job, and we want to thank you. All right, you can be seated. The next case we'll hear, Austin versus Experian. And Mr. Roth, whenever you're ready.
May it please the court, Yaakov Roth on behalf of Experian. Your Honors, this is really a simple and routine case that, in our judgment, just went off the rails below. Experian filed a motion to compel arbitration based on a contract that we say Mr. Austin entered when he signed up for a free credit monitoring service online. And the motion turned on only three facts. Number one, that he signed up. Number two, that in order to sign up, you have to go to the website, put in your personal information, and click a button. And number three, that the terms of use that we say clicking the button assents to, that's a legal issue we can come back to at the end, included an arbitration clause. Those are the three facts. And to prove those three facts, Experian submitted a declaration from David Williams, a corporate executive at the company with whom Austin contracted, who cited his personal knowledge of these facts based on his 20-plus years working for the company and his review of the corporate business records. And in response, Mr. Austin did not deny any of those three facts. Now, in our view, that is a one-sided record that should have resulted in an order compelling arbitration. It was enough for more than 50 other federal courts from New York to California that have looked at cases like this. But the district court here excluded the declaration and on that basis denied the motion. The court said that Mr. Williams lacked personal knowledge of these facts or didn't sufficiently explain why he had personal knowledge of these facts. And the district court also objected that the declaration didn't attach the business records that he said he had reviewed. We think there are a series.
Does the fact that he had actually used the system himself play into your argument?
Sorry, who's he?
I understand in the record.
Yeah, he doesn't dispute that he signed up.
Oh, does that help you or hurt?
I think it helps us. I think the fact that he doesn't dispute any of these facts helps us. So Mr. Austin didn't deny signing up. He didn't deny that the website looked the way we said the website looked. And he didn't deny that the terms of use included an arbitration clause. If he had denied some of those facts, then we might have a dispute of material fact, and then we would need to have a jury trial on arbitrability. There was no dispute. The district court just said, on its face, this testimony was inadmissible, never comes in the first place.
At which point there's no dispute because there's literally no evidence.
Exactly. And we don't argue with that, but we do take issue with the threshold determination that this was inadmissible.
Well, can I clarify then just two things? One, you agree that it is your burden as the party seeking to compel arbitration. It's your burden to establish the existence of a valid agreement to arbitrate.
Absolutely.
So in the absence of that evidence, the right response is to deny the motion to compel arbitration.
Correct.
Okay. And then the second is the district court also has an alternative holding, which I'm sure you'll get to, but
Yes.
just to walk through, if we affirm the exclusion of the declaration, the second holding becomes irrelevant and drops out of the case.
Correct.
Okay, thank you.
For this case.
For this, of course, for this case.
So with respect to the personal knowledge issue and the admissibility, we think there are really four different errors that the district court made, two legal and two more sort of abuse of discretion type errors. First, on the legal errors, this court has in 3 published opinions adopted a presumption that a corporate officer is going to have personal knowledge of the acts of the corporation. That's Catawba, which was on Bank, Apex, and Bryant. It's not the end of the analysis, but
Because it can't be, right? Because it cannot be that Mark Zuckerberg has personal knowledge of everything involving Meta, right? That is facially implausible.
well, but I think that actually helps us, Your Honor, because I think what the cases are really saying is, yeah, if Mark Zuckerberg comes in and says, this junior employee at Facebook or at Meta earned $50,000 last year, we're not going to say, well, how would he know that? Well, he has ways of knowing that. He's the CEO. He can check the records.
You don't rely on the fact that he said he had personal knowledge.
He said he had personal.
And why doesn't that end your argument? It seems to me, somebody says, I saw this at the traffic light, and I have personal knowledge about it. You can question whether the person and cross-examine him later.
Right.
But as opening evidence, it seems to me that
Your Honor, I don't disagree with that. That's our sort of first point, is he said he had personal knowledge. Now, I could imagine an extreme case where somebody says, I have personal knowledge of this.
It could be
and-
just a form statement that is unsupportable, but he explained he's been there and he looked at the records and he
Right.
saw this and he knows the operation of the site.
Right.
The design of the sign-up and explained it. And it seemed to me, even, I don't know if we're allowed to look at the site, but we would probably see the same thing if we went in and looked at the site. We'd see the button that says, by hitting this button, you agree to the
Right.
terms and conditions.
Right.
But
That's right, Your Honor.
he
And
had personal knowledge about that.
Yeah.
It's the company's site, and that's not a very extraordinary thing to say.
And that was going to be my third
I
point.
think you end up twisting yourself into problems as you go on.
I don't want to twist, Your Honor, so I'm not going to belabor it. I agree with everything Your Honor said. He said he had personal knowledge. He has every reason to have personal knowledge because of his corporate position. The things that he is testifying about are not the types of things that you wouldn't expect him to know. This is the service that ECS provides. They sell credit monitoring services. All he's saying is, in order to sign up, you go to our website,
He
you put in your
basically
patient, and click
described
the
the
button.
online design,
Exactly.
and that's it. And it seems to me the online design is either that or it isn't that. And he said it was that, and he knows it's that.
And nobody said it wasn't that. So there was no evidence on the other side.
Well, except, okay, so I'm looking at this right now. He's testifying as to what the online, I'm looking at his declaration.
Yeah.
He says, he's telling me what the design was on May 3rd, 2020.
Right.
In a declaration that he is submitting on February 14th, 2023.
Right.
So it can't be, I just logged on this morning and saw how it looks, because that's 3 years too late, right? So he's got to say, I can tell you what this looked like 3 years ago.
Right. And that's why he says in paragraph 1, that he knows this through review of pertinent documents maintained as business records by CIC in the course and scope of CIC's business, and so on and so forth. He can do that based on the records. Of course, he had to check the records to know that Mr. Austin had signed up. He doesn't know that without looking.
Sure.
But he can say, yeah, I put in his name, his address, his social security number. It popped up that he signed up on May 3rd, 2020,
Yeah,
and our records
seems,
show.
that part seems fine. The part that seems more iffy is if someone asked me, what did Uber's app interface look like 3 years ago? I mean, I know I don't work, but this seems like a materially different question then. I think we're pretty straightforward to how we get to he signed up.
Right.
But then how do we get to how did this look 3 years in the past?
Right.
That doesn't strike me as something that's that obvious that a particular person would be able to testify to based on personal knowledge.
So what I would say, Your Honor, to that is, if they had a real question about that, and I don't know if it actually changed, or
No, I
if the date
understand.
is just there because that happened to be his date of enrollment. But that would have been the perfect question to ask him at deposition. How did you know it's the same version? Where do you store the old versions, right?
Right.
It's the type of thing you can ask if you have a follow-up question. They missed the chance to depose him.
So let me just posit that I think this is a fairly aggressive exclusion ruling by a federal district court judge. You don't have to convince me of that. This is an abuse of discretion standard to review. And so the question is, what is the best case you can cite me for the proposition? You know, you said 50 cases, but then I asked my law clerks to look into this. How many cases did anyone, so the first thing I'm gonna do is I'm gonna exclude every single case where no one objected because the court did not rule in any of those cases.
Yeah.
And it seems to turn out to be the vast majority of those cases. And to the extent courts overruled objections, what did they say in overruling objections? And those cases also tend to be pretty thin in terms of what people actually say. So what is your best case for the proposition that this is not simply an outlier district court decision and is not simply an aggressive use of the federal rules of evidence, but it is a reversible abuse of discretion?
Well, Your Honor, I would point to actually this court's decision in Apex. It's not an Experian case, but I think that's actually the best articulation of how this is supposed to work.
Okay.
Where the court said, you know, the president of the company came in and testified, you know, we never got this invoice, or we never sent, I don't remember exactly what the fact was, something about an invoice. And the person objected and said, well, how do you know? And this court said, well, he's the president of the company.
But we also said
We
that was a
trust him.
small, like, family-owned company, right?
No, it said it says, there's one sentence that says, he was the president of a small business for 30 years. Then it cites Catawba and says, we presume that corporate officers know the things their corporations do. Therefore, in the absence of any contrary evidence from the other side, we're going to assume he had a basis to testify about it. And again, I think the right way to handle that sort of inquiry is to say, all right, well, maybe there's some question here. Let's give them a chance to probe it in discovery, not to exclude it out of the gate. What's really, I think, backwards about how things happened here is the court gave them the opportunity to go through discovery, document requests, interrogatories. We made 2 people available for deposition. And then at the end of that process, when none of it contradicted anything he had said, they went back and said, well, actually, it was fatally, facially deficient at the beginning, and none of the discovery can cure it. And it just seems like it has to be the wrong way to approach it.
I agree with all that. This does seem to have a little bit of a pox on everyone's house problem, though, because, like, there's nothing that would have stopped you from, A, deposing this individual, right?
Well, we don't depose our own person.
You
I mean,
could.
it's-
Is there
I
any
suppose,
rule
but
that says you
that's-
can't?
well, that's what the declaration is, in a sense.
Okay,
It's-
well,
yeah.
you also could, very obviously, have provided a declaration that has some more information, and you didn't do that either.
Yeah, I can't tell you that this declaration could not possibly have been more detailed. It could certainly have been more
Well,
detailed.
and in fact, I think you brought to our attention some of these later some cases that have happened since this. So
Yes.
we read those.
Yeah, and we've added some
You've
sentences.
added some language to your declarations. So I don't know if those cases help you at all, because all those cases tell me is that when you have a declaration that says more, courts let it in.
I agree. We added a few sentences to try to avoid this problem going forward. But chronologically, the way this happened was
Sure.
we filed the motion and the declaration. Then they got discovery, and we went through discovery. And then they moved to exclude the declaration, at which point we said, what are you talking about? Everything he said he was able to say, and nothing in the discovery record casts any doubt on it. So that was the chronology. It wasn't like, oh, we're going to go back and amend our declaration. That had already
It's actually
been
a
in
little
the
more
record.
striking because, I don't know. Well, I was going to say, I tried cases for over 20 years, and the question is, could I put a man on the witness stand and have him say this? And I would be totally shocked if a court said, you can't put that man on because he can't testify that way. It'd be, I'll ask this to your colleague, but it would be not only shocking, it would be something very strange in the trial process. He can say this, he can testify to this, and he can be cross-examined. And the question is, how do you exclude somebody preemptively from saying this? I can't figure out what the basis is. I mean, you have to assume cross-examination of some kind in order to do that, because he can say, I looked at the records, this is what our corporate records show, and I have personal knowledge of that. That's all he has to say.
Yes.
And now, step down, but you don't exclude the witness.
Right. Well, Your Honor, that's why I said I think it's a pretty simple case that has gone off. Let me spend the last couple of minutes addressing the alternative holding, because that's a separate issue, a separate legal issue, where the court said essentially the website wasn't clear enough. This one is also an extreme outlier. I don't think there's any other court that has said that this website as a matter of law is not clear enough to give rise to a binding agreement. And there have been more than 50, I think closer to 70 at this point. More importantly, this court has now decided a case that speaks very clearly to the standards.
Harris?
It's the Marshall versus Georgetown.
Yeah, Judge Harris.
Judge Harris
has
is,
been-
yes,
excuse me,
yeah,
Judge
that's
Harris
right.
has been-
And that adopted pretty clear standards for the first time in this circuit, and we clearly satisfy those standards because the website clearly and expressly says clicking the button constitutes assent. The language is right above the button. It's in bold. The terms of use is hyperlinked
The site, the
in blue.
design, as I understand it, has to steer you through the terms and conditions. If the site doesn't do that and gives you choices, you can't presume that everybody's going to be hitting different buttons.
Right, so for example, if you had to scroll down to the bottom to see, oh wait, I'm agreeing to something here, then we can't draw that inference. That's not the case here because it's right above the button. The terms of use are hyperlinked in blue so that everyone knows I can click on it and see what they are. He may not have clicked, I'm sure he didn't, but that doesn't change the fact that it's a binding contract. And again, this court said that in Marshall, said a hyperlink is good enough. The button doesn't have to say, I agree. It can say continue or register or create your account. So I think most of their arguments on this score have been superseded by Marshall and should be reversed. This alternative holding also should be reversed for that reason.
I assume that it appeared to me that the trial judge relied on, and I'm going to assume that the S is silent, Gouros v. TransUnion.
Skouros, yes.
What's the difference between?
Oh, yeah, very good, Your Honor. So Skouros is the case that this court relied on. It's from the Seventh Circuit. In that case, the website, TransUnion's website, nowhere said clicking the button is agreeing to the contract. It actually said something different. It said clicking this button gives us authorization to pull your credit report. And then they came in court and said, well, actually, it also constituted agreement to this contract. And the Seventh Circuit said, well, you didn't tell them that. And if you don't tell them that, of course, you can't hold them to it later. But that's not how our website looks. The court can look at the two screenshots and compare them, and they're not the same. Thank you, Your Honor.
Thank you, Mr. All right, Ms. Garland?
Good morning. May it please the court. Jessica Garland for Mr. Austin. Experian's position appears to be that the district court was required, as a matter of law, to accept Mr. Williams' declaration. But Mr. Williams' job is Vice President of Business Governance, and although he claimed to have personal knowledge.
Let me just transpose this a little bit. We were in a courtroom during trial, and they call Mr. Williams to the stand. And he says, I'm the vice president of this. I know the records. I've been here a long time. I've checked the corporate records. And based on my personal knowledge of what I've seen, this is the design of the site. And of course, it's not a very unusual design. And he describes the site. Do you exclude that witness preemptively? You can't let him say that from the stand? And he says, I have personal knowledge of this. Can you exclude that witness under any standard?
I think that.
In the courtroom now.
I think that Rule 56E directs.
Listen, you didn't hear my hypothetical. We're not under 56. I'm talking about in the courtroom. I'm bringing Mr. Williams to the stand. and this is what he testifies to. Can you move to strike all that evidence?
Yes, if he can't make an affirmative showing of how he has the knowledge based on what
Doesn't need
business
to. He's
record.
testifying to what he does know.
And I don't,
He says, I'm vice president of the company, or president, or whatever officer. I know these records, I've looked at the corporate records, I've checked his account, he opened an account on March 3rd, I have personal knowledge of this, I saw that, and this is what our account looked like at that time. Now, that's what he says from the stand, on personal knowledge. How do you exclude that?
well, I don't think that he said he looked at Mr. Austin's account.
He said he looked, well, he said he gave a specific date, and he says, I have personal knowledge of that.
I
And he
think-
obviously had, and he said he looked at corporate records. I mean, I don't, you've tried cases, haven't you?
Not at trial, Your Honor, but I do think that it could be excluded, and that's because the district court.
I have never, I tried cases for 22 years. I've never seen somebody excluded from a stand except an expert witness proffered under Dogger.
Well, I think what the district court should do is ask more questions to figure out if he had made the requisite affirmative showing. And that's what the district court tried to do here. It noted that Mr. Williams said in his declaration that if the judge had questions, he would be happy to come testify. So the judge asked him to come testify, and he said no. And then the judge noted.
The judge got angry at that. There's a lot of going back and forth in this record that probably created a bad mood, and the judge took it out. But the long and short of this, though, is that we're looking at a declaration that is just straightforward testimony that is done thousands or hundreds of thousands of times in court every day. And you don't exclude the witness from saying that. You exclude a question, you say, did you see that or something? He says, I think the light was this. You can't testify to that. But that's not what this declaration said. He says, I have personal knowledge, and I'm an officer, and I'm in a position to have personal knowledge of this. Our corporate records show this, and this is the design of the site, which is not a very sophisticated piece of information.
Well, Your Honor, first of all, he didn't actually say that the exhibit was from his corporate records. And when the district court asked
Didn't he say he
Experian,
consulted the records?
he said he consulted, he didn't say what records. And then the district court asked Experian
So
if,
he doesn't have to, you don't have to say that. I mean, that's cross-examination. He can testify to this. There's nothing that says he can't testify to it. I genuinely don't comprehend what rule of evidence is excluding this. You know, Rule 56 says you have to provide admissible evidence, evidence admissible at trial. And it's a summary judgment, and you can put counter affidavits in, you can take depositions, they can take depositions. But as it turns out, this is not illegitimate evidence. That has to be excluded. What rule of evidence do you exclude it under?
I would exclude the business records under hearsay because there weren't any records identified in this.
Business records are subject to being put in simply on authenticity.
I think
And there
that
were no business records that he offered, so you can't exclude that. He said, I looked at the business records.
I agree that there were no business records offered that he said he looked at.
But he didn't have to.
But the problem is for evidence to be admissible that's based on hearsay evidence, there needs to be a showing that that hearsay evidence can be made admissible, and they didn't do that.
Is that your argument?
Well, they did-
Because here a corporate officer says, I looked at the corporate records, and this is what they showed. And they showed that he signed up on this date.
I think that is not enough to make the requisite affirmative showing that this court has said numerous times is necessary. Indeed, the district court asked Experian, you produced numerous records, or any of these records the ones that Mr. Williams looked at, and Experian said that it was not going to make that statement. It could not say that those are the records he had looked at. So the district court did exactly what Rule 56 says. Rule 56E says, I quote, if a party fails to properly support an assertion of fact as required by Rule 56C, the court may give an opportunity to properly support or address the fact. And that's what the district court here said. He said, first, I'm going to order
Well, the
discovery.
presumption to this is that he didn't support it. The question is, he said, I have personal knowledge. The man signed up on March X. He went through the account. We have independent confirmation the guy signed up. And this is what our online design looked like.
Well, we don't have independent confirmation he signed up because
You don't need a confirmation.
I think that the problem here, Your Honor, is that the statement, I have personal knowledge, the district court found did not meet the record showing of demonstrating he actually had that personal knowledge.
So how do you demonstrate he's a liar without other evidence. He said I had personal knowledge.
And I think if he actually had personal knowledge, it wouldn't be very hard to explain why. If you know something,
It may not be, but the question is, does it make that statement inadmissible?
it does make the affidavit inadmissible if it's not based on personal knowledge, and it is Experian's burden and Mr. Williams' burden to make the showing that it was based on personal
Can I
knowledge.
ask you again, let's continue with the hypo. Imagine he's on the stand at trial, and he gets to the part, and imagine he gets on the stand at trial, and he basically proceeds to read this document, right? So his testimony at trial is reading this document, or reciting this document. So then we get to paragraph 3. And this paragraph 3, he said, plaintiff enrolled in Credit Works. And then this is the part where he starts to describe the form. So I guess the hypothetical is he's on the stand and he starts to describe what Mr. Austin would have seen in the form. And then at that point, your client objects lack of foundation. I'm not saying he can't say this. I'm not saying it's impossible for him to say this, but I'm saying that based on everything he said so far, he has not laid adequate foundation for how he can tell me what this website looked at. Do we think the right question is whether the district court not would have, but could permissibly have sustained a lack of foundation objection at that point?
Yes, and I think the district court could. I also want to note, Your Honor, that there wasn't going to be a trial here.
No, I understand. But I think the hypo of, because I think Judge Niemeyer is quite right, that Rule 56 essentially says to use it in this context, it has to be admissible at trial. So therefore, the question we have to hypothesize is, if someone said this at trial, could a district court, without abusing its discretion, sustain a lack of foundation objection at the point he starts describing the website?
Yes, and I know that the district court has quite a lot of discretion. The way that this court has described the court's discretion in Evans is that what this court determines whether the district court's determination that portions of the affidavit contain statements that were not based on personal knowledge for clear error. Here, the district court looked at the paragraphs in the affidavit and noted there's no reason to expect that a vice president of business governance would know the back-end code that showed whether a specific individual clicked on a specific button and saw a specific page just in the ordinary course of business. And he also noted that Mr. Williams was unable to point to any document to support that, despite numerous discovery requests, despite the district court itself asking Experian whether any of the numerous documents that I had produced were the ones Mr. Williams was relying on. To the contrary, again and again, Mr. Williams and Experian was unable to say there is any specific document that provided that information.
Can I ask you not about the declaration, but about the documents? I have a question about some of the documents. So the district court says they're all hearsay, which with respect strikes me as obviously and self-evidently wrong. So for example, like what the website said on the, assuming that we can lay adequate foundation that this is what the website said on a certain day, it seems transparently obvious to me that what the website said on a specific day is not hearsay, because those statements aren't being offered for the truth of the matter asserted. They're being offered to show what a person would have seen. Do you disagree with that?
I think the issue with the documents
Do you disagree with the fact
No, Your Honor.
that the contents of the website on a certain day are not hearsay, and to the extent the district court said they were, that is completely wrong?
I understand that, Your Honor.
Do you understand it, or do you
Yes, I
agree
agree.
with it?
But I think there are two types of documents. There are the exhibits, and they're also the documents Experian produced. And Experian explicitly waived, not forfeited, but waived any reliance on those documents. The court again and again invited Experian to point to the specific documents that would support its motion to compel, and Experian again and again said no.
I thought it's not a document. I thought it's online information. The agreement was formed by going online and going through the website, right? If there is an agreement.
Yes, Your Honor.
So there's no document. We're talking about a website and going through and agreeing or not to the terms and conditions.
Yes, Your Honor.
All right, and he testifies to what the website showed.
He actually never even said that the business records he's referring to are the exhibits
I
attached.
said he testified to what the website showed.
Yes, Your Honor.
Okay.
Yes. And
What do you do with the fact he actually used the system?
Your Honor, I respectfully disagree. I don't believe that's what the record showed. To the contrary, he...
Point me to where in the record that your position is right.
Yes. JA 586 to 589, that's Mr. Austin's affidavit. He explained in that affidavit that he actually expressly told Experian that I, quote, did not agree to the Credit Works contracts and terms, that he never saw that the information on the website that Experian claimed was there about informing him of the terms of use. Indeed, he said he didn't even know what CreditWorks or ConsumerInfo.com was before this case. And the district court found that as a whole, his affidavit indeed showed that there was no mutual assent to arbitrate. So I do think there is a question about what actually happened here. He went to Experian to get his statutorily required free credit report. And he'd never said that he made this agreement and clicked a button on CreditWorks. And it's Experian's burden, which I know it doesn't dispute that it is its burden, to make that affirmative showing. And then it's also its burden to make an affirmative showing that its declarant has personal knowledge when that's all they were relying on is what the declarant said. I also want to note that my friend focused a lot on the deposition that wasn't taken. And I think the reason it wasn't taken was because Experian stonewalled trial counsel below. The court noted, it found, as per Rule 56E, that on the face, the declaration did not make a showing of personal knowledge. So it followed Rule 56E and said, please provide some more. It ordered discovery. Again and again, Experian refused to produce any discovery. There were numerous status conferences and hearings where the court urged Experian to produce discovery. They noted at one of these hearings in March 2023 that there was going to be a deposition taken. But Austin's counsel explained that before that deposition was taken, he needed at least some of the discovery material about Mr. Williams' job and why he would actually have information so he wasn't going in blind. He said, quote, I otherwise would be taking asking the same high-level questions and asking the discovery responses without preparation, and then I'll necessarily have to do the depositions again. And the court recognized that, and the court ordered Experian to produce discovery. It did not. Instead, it stonewalled Mr. Austin's counsel.
Why don't you have a motion to compel? There's a whole procedure to handle that, right?
Well, the court ordered it.
Then you can sanction that. You can also exclude items. You can attorney's fees, all kinds of things. But that's not what's before us.
Well, I think the issue is that it is Experian's burden to make the affirmative showing. I think it's not fair.
It is, but you're describing disputes on discovery that are not before us. The only issue before us is whether the district court appropriately excluded the affidavit of Williams.
And it didn't, because as this court noted in Catawba, when an initial affidavit doesn't have enough information, the court can say, please provide more support for your personal knowledge assertion. And then someone just has to submit another affidavit that provides that additional personal knowledge, and that can be enough. But they didn't do that here. And I know it's not hard to do.
Are you disputing that the website showed what he said it showed at that time?
That is what Mr. Austin has disputed that. He says that is not what he saw when he was trying to get his free credit report.
We didn't see the terms and conditions, but there's a sentence right above the accept or whatever it is that says by clicking this button, you accept our terms and conditions.
Your Honor, that's not the way that the website, as alleged by Experian, is actually set up. And I'm happy to turn to the formation question to respond to that. There's no, according to Experian, even assuming there's personal knowledge, and he did see this website, that's not what he would have seen. The website that Experian describes does not have the notice of terms and conditions.
No, it says what's it say right above it?
Right above it, it says, I may withdraw this authorization at any time by contacting ECS. And then above that, it has a number of bullet points that describe things that could be the terms and conditions. It's only above that paragraph of text that it's notices that there are terms of use.
What does it say? Doesn't it say by clicking?
I'm looking at it right now. Does it not say by clicking, create your account? This is all in bold, colon. I agree and accept to the terms of use, which are in blue, which to anyone who's ever used the internet is a hyperlink, as well as acknowledging receipt of your privacy policy, also in blue, and your ad targeting policy, which is also in blue.
Yes, and then there's other text before you get.
I know, but the question is, isn't that an agreement?
Well,
if you click the button below it.
I don't believe that would, this website would put a reasonably prudent user on inquiry notice. And that's because to determine whether a prudent user is on.
It says you agree to our terms and conditions by hitting the button?
No, the button says create your account.
I know, but it says right above it by clicking.
create your account, and then there's a button that says create your account. So you would understand when you click the button that says create your account that I'm clicking the button labeled click your account.
I think a reasonably prudent user who goes to this website thinking they're getting a government statutorily mandated free credit report could think they don't have to give up any rights to get that statutorily required free credit report. And so that the bullet points,
You didn't read what Judge Heitens just read. I don't have it right here in front of me, but it says by clicking that button, I agree to the terms and conditions, right?
I think the issue is it could be the three.
No, that's not an
Yes.
issue. My question is factual.
It does say that, but then underneath that, it has 3 bullet points that I think that someone could reasonably assume are the terms and conditions, and that's the issue. It's the way that the.
Despite the fact that, again, it's in blue in a way that would make clear to any person who's ever used the internet that that's a hyperlink.
At the very least, I think it could be reasonable to think that's a summary of what the terms and conditions are. Again, I think because someone's coming to this website thinking this is a statutorily mandated free credit report, that they wouldn't be thinking they have to give up their rights or agree to an arbitration.
It's not giving up rights, it's agreeing to terms and conditions.
And
They
so-
may be very good.
And
If
yes,
you don't know what they are, you have to click on the blue underlined portion.
I think that the bullet points
But
are.
the fact is, you agree by hitting the button. That's the big deal.
Well, I think that it could be that the bullet points, a reasonably prudent user would think those are the terms and conditions. And I also know all of the cases that my friend relies on Meyer, Selden, Edmondson, they all focus on the reason that the interfaces in front of those courts were clear enough was because there was no other confusing language, there was no clutter, and the notice that there were terms and conditions was right next to the button. So I think the difference here is, first, someone is coming to this webpage thinking they're getting a free product that they don't have an ongoing relationship with, like with Uber, and so that this could be all the terms and conditions they need to be signing to are the ones in bullet points under that.
Can I ask you to address your friend's argument for why the Seventh Circuit case is totally distinguishable? Let me preface it by saying I think he's right, that the Seventh Circuit case is totally distinguishable, because that decision says, by clicking X, you agree to Y, and now you're being told by clicking X, you actually agree to Z too, and you're like, that's not what it literally says. So the only case the district court relies on strikes me as transparently distinguishable, so do you want to defend the district court's reliance on that case, or go somewhere else?
I recognize the interface there is different, Your Honor. I think the principles that the court was focusing on there,
But one of them is, I didn't agree to that, and the other one is, maybe I didn't see that I agreed to. Your argument strikes me much more in the vein of, I could have reasonably believed I didn't agree to that. The Seventh Circuit case, the person has a much better argument. It's like, I literally didn't agree to that.
I understand that, but I think the point from the Seventh Circuit case is that the court questions whether the interface quotes could mislead the consumer, and I think it could here
It
for
could
different
mislead the
reasons.
consumer, because the consumer might read it, and it doesn't say what the company is now saying it says.
I recognize that it does say, has different text here, but I still think it could mislead the consumer precisely because someone's coming to this page.
So let me ask you this hypo. Let's imagine that the words by clicking your account, I totally understand that in the real thing, there's this paragraph of text and the 3 bullet points. Delete all of those. So it says by clicking your account, and then it says precisely what it says, and directly below that, there's a pink bar that says create your account. You would definitely lose that case, right?
I think it'd be a much harder case, but I think we would likely lose, Your Honor.
Okay.
I would like to just return for one more moment to the personal knowledge question. I want to emphasize that this isn't some ticky-tacky case. There's an important reason to make Experian meet its burden. That's because when a company has total control of records that they're pulling from the bowels of their record system from years ago about what a website interface looked like, there's a real risk not just for fraud, but simply for error. And as Experian's website has changed the interface over the years, and also the terms and conditions have changed. Indeed, Experian in its 28J letter cited a number of cases that it got confused that actually have a different interface. For these reasons, Your Honor, the court should affirm the decision below. Thank you.
All right. Thank you, Ms. Garland. Mr. Roth?
Thank you, Your Honor. Just a couple of quick points. First, on the records and the discovery. And as Judge Niemeyer said, if we had not produced the discovery, I'm certain there would have been a motion to compel.
It looks like it was pretty messy procedures before the district court, and it looks like the district court thought that that was in your lap.
It was a very contentious period of discovery, no doubt. But at the end of it, we had given them what they asked for, which is why they didn't actually file a motion to compel at the end of the day. They said, all right, well, now we're just going to move to exclude the declaration in the first place. And I would just point the court to the spots in the JA where the discovery materials actually are, so we don't have to have a dispute about it. The court can see them.
So can I ask you the question that I asked your friend on the other side? Let's imagine this guy takes the stand and starts reading this deposition or declaration, and he gets to the part where he describes the thing, and they stand up and they say, objection, lack of foundation. And again, I am not saying that it's impossible for this dude to say this. I'm not saying he doesn't have this knowledge. I'm not saying you couldn't lay the foundation that would render it admissible, but based on what you have said until this point, there is a lack of foundation sufficient to support him being able to say this. Do you think the district court who sustained that lack of foundation objection and said, again, I'm not telling you that he can't say this, I'm gonna tell you I'm gonna need a little bit more information before he can just start talking about what the website looked like 3 years ago, that district judge abuses his or her discretion?
So let me give you two answers. One, yeah, I actually think that the answer is yes, based on the material in paragraph 1. I think that's what any district court would expect in that situation, to be able to provide that testimony. But I will also say that in this posture, where we are at the declaration phase, and the court then authorizes discovery to probe the basis for the declaration, that's not really the question we should be asking. We should be saying, in light of everything that happened, that followed, did they get the assurances they needed and were entitled to the extent it was more than he initially provided? And they did. And again, I would point the court to, of course, there wasn't a deposition because they didn't take it, but the documents, JA 1946, we have over 100 pages of spreadsheets documenting every time he interacted with the service. JA 2564, we have hundreds of pages of additional spreadsheet documents that actually identify every click on the website that he, when he first opened the account, every click.
Didn't you waive every single bit of this?
So-
Like, didn't you basically say, having excluded our declaration, we're not,
Yeah.
it sounds like that's all of the stuff you totally waived before the district court.
So let me address, that was the next point I wanted to make. We absolutely waived the right to argue that was independently sufficient to support the motion to compel arbitration. We did that.
That once we lose the declaration, we can't do it.
Yes, and we did that because this comes up a lot for us. We have sued a lot, and it's important to us that we can do this through a declaration, because that's the easiest, cheapest, fastest way to do it. It doesn't get into sealing records of social security numbers and all sorts of other things. So the principle was important. So we waived that, but we did not waive the argument that to the extent they had any issue with the declaration, the right way to address that concern was through the discovery, that they had the opportunity to do that it didn't actually substantiate any of their hypothetical concerns about the declaration, and that should further corroborate that the court erred by striking it. So there's a difference between those two things. The last thing I'll say is, if the court does look at Mr. Austin's declaration, it's worded very carefully, but I think that the takeaway is clear. He says, and this is at JA 585, he says, I inputted my information to request my free report. I never agreed to purchase anything. That, of course, is true because it was free. Then he said, I used the Experian website to look at my credit report when I first provided my information, and I believe a couple of additional times for the same purpose. So he is admitting that he used the service, and he says he never saw the terms of use arbitration agreement, which makes perfect sense if he didn't click the hyperlink. And then he says, I don't recall seeing language to inform me of this terms of use agreement. Of course, the fact he doesn't recall it, no court thinks that's enough to create a disputed material fact as to whether it was there. So, sorry for going over, Your Honor. Thank you for your time.
All right. Thank you. We'll adjourn court for the day, come down and greet counsel, and ask counsel if they would approach the bench to greet Judge Floyd.
The Honorable Court stands adjourned until tomorrow morning. God save the United States and this honorable court.